My lord, I am mentioning item number 41 and 42, contempt matter, my lord. Here, what has been complied with, my lord.
Other
It is
side,
a petitioner, my lord. They got promotion. 41 and 42, my lord.
Sri R. Dhar, Learned Counsel, appearing
All
for
the,
the respondents in these cases. No, a single alag one. In this case, submits that they ordered it is so and so, passed in so and so, has been complied with. Sri, your J.M. Gogoi. Sri J.M. Gogoi, Learned Counsel for the petitioner, endorses the said submission. Full stop para. In view of the aforesaid submission, this court is of the opinion that there is no reason to continue with this proceeding. Full stop. Accordingly, the contempt case is closed. Alag order. Second May order will be changed. WPC will be changed. Okay. CD file.
Item 41 and 42.
Yes.
May I please, your lordship? I would like to mention item 4. I am newly engaged, your lordship. I'll file wakalat nama. So 2 weeks time may be granted, lordship. Item number
Matter of
4.
which year?
19, lord.
19 matter.
Lordship, just yesterday I am engaged, your lordship.
Not yesterday.
Yes.
No, we know when we are engaged. Not yesterday.
Lordship, 2 weeks, 1 week may suffice, lordship.
It has come down to 1 week now. Some
I'll
more.
file wakalat nama by tomorrow, lordship.
You don't need wakalat nama if you are instructed by the other council. You file it.
Yes, I have instructed.
Okay. When do you this matter? Do we take it up? Admission hearing.
Lordship, can take for 1 week, Lord. 4 weeks matter
Oh,
is
1
very
week.
urgent, Lord.
1 week, lordship, 1 week.
1 week.
For 10.
Yes, see, urgency is there. Sri Shom, Learned Counsel, submits that he has been instructed to appear on behalf of the petitioners, and he would file the formal power shortly. Full stop para. As urgency has been expressed by the Learned Counsel for the other, for the Learned Counsel for the private respondent, comma, comma nahi, and also keeping into account, keeping in view that the matter is of the year 2019, list for admission hearing on 25th July. For 25th July. No, today is 24th.
24, lord.
On 1st of August.
First, lord.
First of all.
Oblige, lord.
May I please, your lordship?
1st of August, but for disposal.
Lordship.
May I please, Lordship, I like to mention 5 numbers of my lord physically handicapped quota case, my lord, to be listed any day next.
Second bench, not before here. There's senior bench.
May I please, your lordship? With the consent of the petitioner, I beg to mention item number 40. Lordship,
1440.
40. Contempt case, lordship. We are appear for respondents. Today we have some difficulties. May I pray to come up this matter after 2.
40.
40.
40, I think. Oh, okay. You have informed the other side?
Yes, Lord.
Okay. On a prayer made on behalf of Sri K. N. Chaudhary, Learned Counsel for the respondents, list after a week,
2 weeks.
list after 2 weeks.
May I please, Lord? Okay, I beg to mention item number 36.
26.
36,
36,
36, Lordship. With the
36.
consent of the petitioner, Lordship. I am
Yes.
for the respondent Oil India Limited. Lord. We need 2 weeks time to file a affidavit in office.
Okay. On a prayer made on behalf of
the
respondent
respondents.
Oil India Limited, 2 weeks time is granted to file affidavit in opposition. 36, huh?
Much obliged.
May I please, your lordship? Lordship, with the consent of the petitioner, I beg to mention item number 32, lordship.
Yes.
Lordship, I am for the standing counsel of co-person department, Mr. P. Raskol, lordship. Lordship, kindly list the matter of that with.
Have you filed wakalat? Have you filed your affidavit in opposition?
Lordship, we will go good. We'll file.
Now, have you filed or not? Not filed.
Not.
You file it in the meantime. We'll grant you some time.
Lord.
Have you informed the other side?
Yes, sir.
A prayer has been made on behalf of Sri V. Rajkhwa, Learned Standing Council Cooperation Department, for adjournment, full stop para. It also appears that affidavit in opposition has not been filed.
Check
Para?
everything, sir.
Hmm?
Check everything.
List after 3 weeks. By which time?
Your Lordship, my apologies. Your Lordship, we have already filed affidavit in opposition on 19/3/2020.
Okay, don't write this. You should read the file before you come. Okay, last part, but don't. A prayer for adjournment has been made on behalf of Sri Bhiraj Kaur, understand? Para. No, don't write the external. On a prayer made on behalf of Sri V. Rajkol and Standing Council Cooperation Department, letter is adjourned to be listed. When? After 1 week?
2 weeks.
Listed on 5th of August. 5/8. Yes.
Firstly, I beg to mention item number 53, madam. I have taken the consent from the other side, madam. Mr. Pathak has some personal difficulty today, madam. So matter may be taken after 2 weeks.
On a prayer made on behalf of made by Sri V. Kumar, Learned Counsel for the petitioner. Matter is adjourned to be listed after 2 weeks.
Right.
Okay.
I wish to mention item number 10 to 13, 24, 29, 34. Sir, I put up under treatment.
Okay.
I have taken consent order.
Okay. It is submitted that Sri S. Bothakur Learned Counsel is under bereavement. List after 2 weeks. Separate orders, huh? Please give the numbers.
Sir. Thank you.
Who has passed away?
Order.
Is it? Oh. When was it?
Yes, sir.
Yesterday.
Hello.
May I please the Lordship? I beg to mention item number 51 with due consent of the other side. I am for the respondent.
51. Yes, what is your prayer?
For all the respondents,
You want time?
Lordship,
This is 16 matter, madam.
Lordship,
Where are you seeking time?
Lordship.
Why are you seeking time?
The Learned Counsel CGCB Deka, his wife is in the hospital.
Okay,
It's admitted.
okay. You inform the other side.
Lordship,
Have you informed the other side?
Lordship, through telephonic.
Okay. A prayer for adjournment has been made on behalf of Sri B. Dekal and CGC by citing medical grounds, by citing medical emergency. Full stop para. Considering the above, as well as taking into account that the matter is of the year 2016, a short adjournment is granted. Directing listing of this matter after 1 week.
2 weeks, Lordship.
Adjournment is directing listing of this matter on 51 on 5th of August.
Lordship. Highly obliged.
Yes.
May I please, Lord? I beg to mention item number 21, Lord.
Mr. Sekhi, which matter? Where are you
I
standing?
beg to mention item number 14, my lord, 14. In this case, my lord, senior counsel K. Chaudhary has been recently engaged, my lord.
Okay,
He is in bereavement, my lord.
okay.
May I pray, my lord?
1 to 4. 4 has already been
1,
4, my lord, 14.
1, 4,
1,
14.
4.
Okay.
Okay.
Oh, you have made a mention yesterday. I
Yes,
think.
my lord. 5th or 7th, my lord, August.
Okay. Who has passed away?
His
Who-
mother-in-law.
Okay. Sri S. Mukhtar, Learned Counsel for the petitioner submits that he is led by Sri K.H. Chaudhary, Learned Senior Counsel, who is in bereavement. He accordingly prays for and he is accordingly prays for an adjournment. Full stop para. List after 2 weeks.
5th or 7th, my lord.
Matter is accordingly adjourned to be listed on 7th of
Right.
August.
Obligement.
Other side inform, Mr.
Yes, sir.
Yes.
May please, Lord. Item number 36, a mention was made in the morning for respondent All India Limited.
Yes.
My only prayer is my name will be recorded there for All India. For filing of affidavit, we have taken time.
Okay. name of Sri A. Sharma be reflected for as counsel for the respondent.
Yes, sir. Obliged.
May I please, your lordship? I beg to mention item number 21, lord.
Yes.
My senior is on late, lordship, so matter may be taken a password for the day, lord.
On legs now? Have
No,
we reached the matter?
Sorry, lord, he's on leave, lord.
On leave?
Yes, M.U. Mahmood.
Okay. We'll have it out next week.
Yes, lord.
A prayer for adjournment has been made on behalf of Sri M.U. Mahmood, learned counsel for the petitioner. Other side informed?
No, lord.
If you don't inform the other side, how can you make a mention? Don't make a mention. Let the matter reach. Yes.
May I please, lordship? May I plead for listening for investment matter? Other parties for promotion matter.
Fresh matter, not
No,
before
no,
here.
no.
There's a senior bench, not here.
May I
Yes.
please, your lordship, I beg to mention item number 27.
Yes.
Lordship, the engaged counsel Miss S. Abdullah is out of session. Therefore, matter may kindly be taken after 1 week.
Item number
27.
it is submitted. You have informed the other side.
Yes, lordship.
It is submitted that the learned counsel conducting this case is out of station. And accordingly, an adjournment has been sought for. Para, list after a week.
May I please, your lord, I beg to mention item number 47. The consent of the other side, that today I filed affidavit in opposition.
We need 3 week time for file our reply.
In the, you have filed affidavit in opposition in the IA or IA? Your name, Asbar Ali?
NK
Oh, your name?
New.
NK New. Your name is not there. You're Mr. Borali.
On behalf of Asbar,
Okay. Sri NK New, learned counsel for the
respond number 3
respondent number 3 submits that the affidavit in opposition has been filed today.
today.
Full stop. On the prayer of Miss S. Roy, learned counsel for the applicant petitioner, matter is adjourned by 3 weeks to enable filing of rejoinder affidavit.
Only.
Is there any interim order?
Yes, Lord.
Hmm?
No, Lord.
Okay.
I'm sorry, my lord. For finance, I have informed. Item number 20
Item number?
21.
Okay. लिखा था ना MU Mahmood? अभी just after a week.
Obliged.
On a prayer made on behalf of Sri M.U. Mahmood and counsel for the petitioner, matter is adjourned to be listed after a week. Yes.
Item 56, something is.
Lord, this IA we have filed for vacating of the interim order. The dated 11/7/2024. Lord, Lord, you will find the order at page 16, Lord, Annexure 1.
Has come up for the first time.
It has come for the first time.
We filed an objection yesterday, day before yesterday we received, and they supposed to come, so 1 week time maybe we had objection.
When did you file?
Lord, we filed on 22nd, Monday.
Monday. Okay. We grant some time.
Lord, just I have to apprise your lordship, Lord. Lord, our transfer order was stayed, but before on 3rd of July, the transfer order was issued. On 5th of July, he was relieved. But without mentioning that in the writ petition, the stay order was granted by the Honorable Court on 11/7/2024. But in our application, we have stated that some preliminary investigation is going on, and that is what the difficulty we have. Because of pendency of this writ petition, they are apprehending because they are facing difficulty to go ahead with that.
With the?
With the investigation and all these things for a subsequent action, they want
We'll pass appropriate orders. There is no bar with the preliminary. It's
Yes,
only subject matter is only the transfer.
only transfer. And he has already been relieved, but he has not followed that.
That will consider.
Lot.
Let us have his
Lot. Let him-
response. Okay.
Lot.
Heard Sri Dinath, learned counsel for the applicant, who by means of this application has prayed for vacation of the order dated 11/7/2024 passed in the connected writ petition. What's the para? Sri M.J. Barua, learned counsel for the opposite party writ petitioner. However, prays for some time to file objection, full stop. List on,
The date may be 1 week.
with, you file within 10 days, we'll fix your date
Yeah.
within 10 days.
Okay.
List on, today is 24. List on 5th, by which time the objection is required to be filed. Interim order passed earlier to continue till the next date of listing.
But, can I prefer liberty my lord, to the authority to go ahead with the whatever action they have initiated, my lord, they will do it. Because
The para, Sri Nath, the learned council has submitted that a preliminary inquiry has been conducted which has not proceeded, which the authorities have put on hold because of the interim order. And he prays for a clarification, full stop. The aforesaid aspect would be considered on the next date.
but it is in fact, my lord, because of some complaints have come, and that is why, my lord, ultimately the order
No,
was to be
we'll
passed.
clear it.
But
My lord,
It
not
is-
a single
on
no-
5th.
not a single notice
No, no,
up till
it is-
today, my lord.
it
They
is-
have now
it is a-
developed their case. my lord.
it is a preliminary inquiry, my lord, notice is
No
not to be
notice
given.
is nothing.
It will come later on, my lord. It is not.
On 5th, we will consider.
But
Mr. Borua, you may not be entitled to a notice. If it's a preliminary inquiry, it's
My
not.
lord, no notice. And today only I surprisingly
No,
learned.
in a
No, no, in the
preliminary
IOF
inquiry,
side.
where is the aspect of notice?
In the IA, we have
They
said,
can make a discrete inquiry,
Yes,
but
yes,
based
they-
on
they-
that, they have to make a
Yes,
proper
yes,
inquiry,
they are
giving an
liberty,
opportunity.
And then it is a punishment transfer, my lord.
No, no.
Notice is required.
Okay,
I-
no, no.
5th will consider.
in our petition, we have said, my lord,
5th will consider.
Yes, yes.
but, they will go ahead with that.
We were not saying anything. On 5th will
Lordship.
consider. We have just recorded your submission.
But-
5th will consider.
But in that case, my lord, the exchange lordship has put that they have hold it, my lord. It will ultimately go against us.
Oh, my lord.
In that case,
No,
case,
you have put on hold. We
But-
have not said we have passed any order.
no, my lord, they are going with the inquiry, and in the meantime, the order has come.
So what is the issue then? Why do you need a clarification?
But since the matter is now pending before.
So you have kept on hold. What is the difficulty in
In
making?
that case, my lord, that part is not.
Last part. Nick.
All right.
And I've taken exception a lot, but as far as this post is concerned, assistant engineer IT, there is no, in the service rule of the PG department, there is no such available post a lot. In fact, in our affidavit, additional affidavit we have filed, at page,
But you had initiated a process to
My
fill up
lord,
the post by
advertisement, my
APSC.
lord, APS.
APS. But we have already communicated, to the secretary to APS at page 47 of the additional affidavit, your lordship, which states that with reference to letter said above, I'm direct to inform you that there is no provision of IT personnel in the existing Assam Public Health Engineering Service Rule 1996. However, it was assured that the existing service rule shall be amended, incorporating 11 qualifications, but as of now,
Mr. Borpia, you have gone through the stand.
My lord, then they are
If-
saying, my
if
lord.
We cannot force them to have a post.
No, my lord, but they have made an advertisement, my lord.
no,
What
but-
happened to that recruitment process?
No, if this post is not, have you filled up this post?
no, your lordship, there's no for the post gonna fill up.
Then the advertisement was issued by oversight or what?
My
have you-
My lord, advertisement was issued by the APSC along with the other.
No, it was by oversight or what? It was by
It was by, it's not by oversight,
by
lord.
mistake or error or what?
It's not an error, your lordship. That's why.
It
thereafter
cannot
we
be
com-
oversight, my lord.
that's why
Other than-
thereafter we communicated to the
Where
secretary,
is the statement in the affidavit?
at additional affidavit which we have filed, your lordship, at page 47, your lordship. The letter from the deputy secretary to the secretary Assam Public Service Commission, sir.
Additional affidavit.
Yes, your lordship. Additional affidavit filed by the secretary PFC, sir.
Please read,
Page 47, your lordship.
please read.
With reference to letter cited above, I'm right to inform you that there is no provision of IT personnel in the existing Assam Public Health Engineering Service Rule 1996. However, it was assured that the existing service rule shall be amended incorporating 11 qualifications, but as of now, the amendment of the existing service rule is not completed. At the juncture, recruiting of AE IT personnel in the department without any provision in the service rule may arise future complications.
Okay, okay.
This being fact, you are therefore request kindly postpone the process of recruiting AE.
Okay. Heard. J.I. Borbuya, Learned Counsel for the petitioner. Also heard Sri R. Gogoi, Learned Standing Counsel, Public Health Engineering Department. Madam Sharma for
6 and 7.
APSC. P. Sharma. Ms. P. Sharma, Learned Counsel is present for the respond numbers 6 and 7. That's APSC. Full stop para. Please have your seat. The grievance of the petitioner was is with regard to non-completion of a recruitment process initiated by the department through the APSC for filling up the post of Assistant Engineer IT. Full stop. As per the facts projected, comma, on the petitioner was appointed as Assistant Engineer IT, PHE Department under Regulation 3F of the APSC within bracket limitation of functions bracket close regulation 1951 wide order dated 16/6/2014. Full stop. Though the petitioner was working on the strength of extension orders, comma, the post was sought to be filled up on regular basis via an advertisement dated 31/12/2014, in which this particular post had appeared against serial number 2. 2, right?
2, Your Lordship.
2. Full stop. It is the case of the petitioner that though he had duly applied for the said post, comma, no steps were taken by the authorities to bring the process to a logical conclusion. Full stop. In the meantime, comma, the engagement of the petitioner under Regulation 3F was also discontinued. Full stop. Para. The Learned Counsel for the petitioner has submitted that since he was appointed in the said post under Regulation 3F, comma,
It's a sanctioned post.
that indicates that there is a valid sanction post and the authorities were under a bounden duty to at least complete the process of recruitment by fairly considering the case of the petitioner. Full stop. However, comma, the same has not been done without any valid reasons, and therefore an appropriate direction is liable to be issued. Full stop. He has also submitted that there was no delay in approaching the court as this petition was filed in the year 2016 itself,
Well,
immediately after his discontinuation in service. Full stop. Para. The Public Health Engineering Department has filed affidavit in opposition on 10/7/2017, as well as an additional affidavit on 1/11/2022. Full stop. By referring to the said affidavit, more particularly a communication dated 8/1/2018, comma, Sri Gogoi, the Learned Counsel, has submitted that though there was a contemplation to have such a post in the cadre of the department, comma, the same was not approved, and therefore the recruitment could not be done. Full stop. He submits that when the post itself is not there in the cadre, comma, making of regular appointment is not will not be permissible under the law. He has also clarified that the post was included in the advertisement on the contemplation that the rules would be amended to incorporate the post, which has not been done. Full stop. Para. The reasons prescribed for to justify the stand of the respondents not to fill up the post on regular basis appear to be bona fide, as in absence of a post in the cadre, comma, regular appointment is not permissible in law, full stop. This court has also noticed that the aforesaid document dated 8/1/2018 issued by the department to the APSC has been supported by an affidavit, full stop, para. In view of the above, comma, this court is of the opinion that no effective relief can be granted to the petitioner in this case, and accordingly,
My lord,
the writ petition is dismissed.
my lord, what I say, my lord, shall not be filled up by the ad hoc appointee. It is there in the interim, my. There shall not be appointed.
There's no post already, how can you fill up?
My lord, they already do, my is a sanction post. But that clear, and my whatever they have deducted from my salary, that to be returned.
No, if there is no post, why should we make an
Yes, sir.
observation?
My lord, they will do, my lord.
Let them do, you come up, then they'll be, we'll.
And whatever
we'll
they have
not have a-
deducted from my salary, my lord, that to
Let
be
them go and make
returned.
a representation before the authority. We have to
Deduct-
deduct it.
Deducted for?
They have, my lord, deducted from my salary, my lord, some portion of amount, my lord,
Why?
In
during
fact,
my
that we have
service
also stated
period,
in our
my lord.
affidavit, Your Lord.
Why?
Affidavit we have filed, Your Lordship. In paragraph 4,
Why deduction?
deduction, he is wrongly claimed that GPF subscription was deducted from his salary, Your Lordship. He was a member of self-financing NI scheme and deduction were made from his salary as per his own option, Your Lord. That's an taken affidavit.
That,
And if
whatever they have retained, my lord, that has to be returned.
even he has
no
not,
purpose
there
to
is not a
submit.
prayer in his writ petition, Lord.
Prayer is
Let
there,
him
my lord.
approach
There,
the authority if he has any deduction we have made. Let him prepare
prayer is there, my lord, to pay my all the arrears.
At this stage, Sri Barbuya prays for release of his entitlements by the department, full stop, para. The petitioner may make appropriate application before the department, which should be considered in accordance with law.
Very well.
The time limit be given, my lord.
File it, let's see,
Obliged, Lordship.
Respondent, but
not 6, 2.
Highly obliged, Lord.
P. Sharma.
My lord, the petition stands disposed of.
Yes.
Kindly pass about a matter of time being, Lord. Or next in another court.
What is the matter?
PWD.
PW, after some time?
Non-payment of pensionary benefit.
Pension, okay, let him come after some time.
May I preach, Your Lordship? Lordship, matter pertains to 2018, Your Lordship. The petitioner was selected by a selection committee for the post of Gangura. And after his selection, Your Honor, one FIR has been lodged against the present petitioner. And on the basis of that FIR, I was not appointed to the particular post. But later on, Your Honor, the complainant itself withdrawn that FIR against me, that I have filed in affidavit, I have filed that order of the Honorable Court. Later on, when I approached that the particular case that has been filed against me has been dismissed and I have been acquitted. Later on, I have filed representation back in 2018 itself. That has also not been considered. Only on the pretext that an FIR has been filed, I have been deprived of my.
But the post, is it filled vacant? Is it still vacant?
As far as my instruction, Your Lordship, recently I asked him to inquire. It is lying vacant.
After the instruction, Lordship, that the post remains vacant, Lordship.
And
No
consider
new
his case.
advertisement was published, Lordship.
No new advertisement.
No, Lordship, as per the instruction.
Consider his case.
Lordship,
Where is the acquittal order?
this is the instruction.
Where is the acquittal order?
Acquittal order in affidavit.
Page.
Page.
Yes.
My lord, I have filed the affidavit, my lord, but unfortunately, my lord, the office code is not.
Which page? Should not come like this
Yes, my lord.
for a disposal of a matter.
I beg your pardon, my lord. It's
How are you assisting this court if you don't have,
unintentional.
you're not even equipped with the papers?
Unintentional, my lord.
Don't take matters so lightly.
Right.
We would have otherwise gone ahead with the disposal, but you're not such a, you're not that much of standing that you don't have the papers. You're a young lawyer. At least you could have had the court records. Learned counsel for the petitioner is not wired to, is not equipped with the records of the case. Para, list after 4 weeks. We don't give indulgence of this kind. Don't expect.
I beg your.
Item 5.
May please, your lordship. Here in this case, your lordship, petitioner was dismissed from service
Yes.
while he was working. Thereafter, we had filed before this honorable court that single bench judgment has declared that all the constituent benefits allowed with backward. Thereafter, the
Dismissal was set aside. Dismissed from which FCI?
FCI, by the single bench, your lordship.
Now dismissed when?
It is a matter on your lordship.
Okay, he was dismissed, then he was.
Then FCI have second final.
Dismissal was set aside.
Lordship, with the dishonorable court directed to give all the beneficial conjugal benefits with back wages. And thereafter, on the basis of that order, have been challenged before the appellate court.
Yes.
Before the division bench, and division bench passed an order, set aside the back wages order.
Okay.
Of the single benches order of the back wages. Other
Yes.
benefits will be remain same. Thereafter, your lordship, on the basis of that appellate order, they have filed before the SLP. Then SLP has not interfered the matter and confirmed the single bench order.
Okay.
Whatever has been there. Now,
Accept the back pages.
accept the back.
Okay.
Now I have, again, I have approached.
We have paid everything. My lord will see our affidavit.
Lordship,
We paid.
Kindly see our affidavit, page number 61 of our affidavit. There is
No,
nothing.
what is the grievance?
now lordship is that I have received all the conjugal benefits except the CPF fund.
CPF we have paid, my lord.
Now, my humble submission before this honorable court, your lordship, they have said about that, if the lordship, about the affidavit, they said about that the petitioner service was effect from 16/9/2002. And my date of retirement is 28/2009. The issue remains is that, your lordship, that CPF fund which they have mentioned about it, your lordship, they have given one bhasha that have been annexed. It is on letter on 12/4/2005, your lords. That letter they have said it about my amount, but that letter doesn't speak about the CPF number also. That is the one issue. Second point is that, your lordship, what I'm pointed. If lordship permit me to go to annexer 6,
Yes, please.
my 6, your lordship, 31/8/2005, the issue have been issued to the manager administration from the Dibrugarh, your lordship. They said that with reference to the cited above, it is informed that as per so and so, gratuity and final education and half pay leave has also been paid. So they have paid me the half leave pay as well as CPF. Now my CPF starts from a lordship annexer 8/34. I have joined on 1974. And they have said about the 2000. And there are contents and there are credibility. They say that I have been regularized from the service of 16/9/2002. And I had joined in 1974, your lordship. After back of 1929 years, they have not mentioned about that gap period.
Yes, Mr. Chakraborty.
My lord, kindly see page 61, serial number 61. Please. We have,
61.
what we have paid to him, we have taken.
61.
Page 61, or that is our affidavit in internal page 3. Serial number 61, page number.
Yes.
These are the amounts which has been paid to him.
4,90,474 released to the petitioner, CPF.
That is the about they have said, but issue remains is that that is on the year 2005, your lord. And the conjugal development part takes place on annexer 6, 31/8/2015, Your Lordship. They categorically mention about the final CPF has been processed under process. Annexer 6/7, Your Lordship, this annexer letter says.
And my lord, latest letter that we have received from zonal office on 18/3/2024, which also says that my lord, there is no outstanding.
The letter which have been mentioned, Your Lordship, is of 2005. The letter which have been on the basis of that letter which have been issued 2/5/2005, Your Lordship.
No, see, Mr. Gogoi, the prayer relief pertains to payment of your consequential benefits, of which CPF is one part. Now they have made a statement that they have paid the CPF. You are raising an issue that is not the proper calculation.
Right.
Then you have to make a specific challenge. That was not the issue before us.
No, Lordship, this is the amount, if Lordship permit me, I will file my rejoin the affidavit on the point of.
No, if you are not
I have mentioned in my affidavit, Your Lordship, if Lordship permit me to, so my
no,
affidavit.
that will be going beyond the purviews of the writ petition.
Okay.
Writ petition was pertaining only to the consequential benefits after setting aside of your dismissal order.
Okay.
They have said that they had paid all benefits, including CPF. You are raising an issue that those CPF has been paid, that has not been properly calculated. So it's an independent issue. Aren't you supposed to raise it independently?
Lordship, now.
And those parts, are we entitled to go into it? What is your how have you calculated?
That is the, I want to know.
My lord,
How have you calculated? Have
that
you given the
calculation is not-
calculation?
my lord, recently that on March 2024, my lord, we have received a letter. from the-
Okay, to avoid multiplicity, you do one thing. You take instructions, how you have calculated the CPF. We may agree with you, your calculation, but let him know at least.
Yes, that
Okay.
is really fair for us.
Uh,
And if Lordship permit me, in that thick cash memo, they have later one, they have not mentioned about the CPF.
we'll
If-
say that. No, here in the affidavit, they have made a mention.
It is their amount is same, Your Lordship, but the basis on the one letter, Your Lordship. They have not mentioned about the CPF.
That will not make any difference. He'll explain it.
Lord.
Okay. Her Dr. Gogoi, learned counsel for the petitioner. Whereas Sri Chakraborty, learned counsel is present for the FCI. Full stop para. There is a checkered history of the case, including history of litigation, history of previous litigations, full stop para. The petitioner was dismissed from his service and the aforesaid dismissal order was set aside by a single bench of this court with a consequential direction, with a further direction to pay all consequential benefits, including back wages.
Lord.
Full stop. The FCI had preferred an appeal in the Honorable Division Bench, which however did not interfere with the dismissal, it did interfere substantially with the initial order, and only the issue of back wages was interfered with. Full stop. The further appeal of the FCI before the Honorable Supreme Court by way of SLP was dismissed. Full stop. It is the case of the petitioner that consequential benefits, more particularly the CPF has not been paid. Full stop para. In the affidavit in opposition, Sri Chakraborty, standing counsel FCI, by referring to the affidavit in opposition filed on 17/2/2021, more particularly paragraph 3 thereof, has submitted that the details of all consequential or details of all payments, including CPF, has been given. Full stop. It is stated that an amount of rupees 4,90,474 has been paid towards CPF. Full stop para. Dr. Gogoi has, however, disputed the amount and also raised an issue that the calculation has been vaguely done and there is no reflection in the concerned order about the aspect of CPF. Full stop para. To avoid any further litigation and to bring this matter to a logical conclusion, comma, let the FCI place on record as to how the aforesaid amount was calculated. Full stop. The same may be placed by way of an affidavit, additional affidavit, which may be filed within a period of 3 weeks from today. Full stop.
Deeply obliged.
Based on the said affidavit, comma, an endeavor would be made to dispose of the writ petition.
Lord, I'm deeply obliged.
Item 6.
Please, Your Lordship.
Yes.
Lordship, this matter was also argued by senior counsel, the details of the Lordship. Matter relates to the.
Item number 6.
Yes, Your Lordship. Lordship, the petitioners were appointed as the assistant government pleaders in different FD, Your Lordship, honor tribunals by notification dated 23/2/2016, Annex of 4, Your Lordship. After the satisfactory completion of matters, Your Lordship, they were allowed to continue, Your Lordship. But the respondent number 1, Your Lordship, by notification dated 8/9/2020, she terminated their appointment, Your Lordship.
Yes.
Lordship, the office Annex of 4 is the notification 2/3/2016.
Page.
Lordship. Page, Your Lordship. 23, Your Lordship. Serial number 11.
Page 2023.
23, Your Lordship. And the impugn notification is, Your Lordship, at
See, where are you? You are from Dhubri.
Dhubri, Your Lordship. Aminul
It's
Islam.
serial number 11.
Yes, Your Lordship. Aminul Islam is the petitioner. Kamal Hussain Ahmed. There are 7 petitions, Your Lordship. Aminul Islam, Kamal Hussain Ahmed, P. Sardar, Harunul Rashid.
Okay. Dhubri is your concerned district. Now, where is the termination?
Lordship, it's in page 28, Your Lordship, Annex 7.
Okay. Yes.
Lordship, in their place, Your Lordship, respondent number 4 to 10, they were appointed, Your Lordship. That is in page number.
Okay. The same page, I think they were appointed. Appointments order were also at page 28. Appointment order and termination order were together. Numbers were different.
Your Lordship.
Okay. Now,
Lordship, this matter was already argued by this.
no, that is okay. What are your grounds?
Lordship, they were terminated, your lordship, without giving any sufficient cause, your lordship, any sufficient reason, your lordship.
How were you appointed?
Lord-
How were you appointed?
Lordship, the initial 2 years of service, they have served your lordship.
How were you appointed? What was the mode? How were you inducted in service?
Lordship, there was an office memorandum, your lordship, that is page 20, your lordship,
20.
20, annexure 2, your lordship.
Yes.
Regarding the appointment of assistant government leaders in Fairness Tribunal.
Hmm.
3 numbers of advocates, the department along with advocates. So the recommendation was made, your lordship, that is.
Was there any selection? What is the doctrine of pleasure, madam? Do you know something called pleasure doctrine? You know? What is it? You have not heard of pleasure doctrine. What is the meaning of pleasure doctrine? Hmm? Did you compete with the others to be inducted in service? Or were you favored by somebody?
My past approved orders.
But you have not answered the question. See, your initial appointment was not by any validly held recruitment process. And these are posts of very temporary nature. Council. Council cannot be permanent. As long as your client wants you to be the council, you will be the council. You cannot force yourself to be the council of somebody. You should, that much of liberty the client has. The government is your client. Government doesn't want you. Government wants to give somebody a chance also. So where is the illegality? Yes, Mr. Mazumdar, anything?
My ultimate submission is what is falling from your lot. Others also should get chance. They were appointed for 2 years in 2016.
But the appointment letter does not specify 2 years.
No, man.
Madam has said 2 years, but we have also looked. From where are you making 2 years? The submission of 2 years. Is it there?
Lordship, in page number 18, your lordship, serial number 5. The tenure of assistant government leader shall be of 2 years.
Oh, that was the memorandum. No, in your appointment order, there is no such clause.
And it says for 1 year because appointment letter contains a notification of 27 June 2013, which your lot will find at page 24. It says it's only for 1 year, renewable only after satisfactory performance.
24.
Page 24. This is referred in the appointment letter. Under the terms and conditions issued earlier by number so dated 27/6/2013 at page 23. Just
1 year.
Yes, 1 year. And they were allowed to work for 4 or 5 years. Now, if an inquiry is made that your service is not satisfactory, it will be a stigmatic man. Government doesn't want that. He has his own independent profession, he will be adversely affected. And it's not a termination, it's basically discontinuation.
Discontinuation.
We have filed an affidavit saying this.
Okay. Madam, your name?
Chief, I am FN Jaman.
FN.
Yes, sir. On
Heard,
behalf of MS Hard.
heard Miss FN Jaman, Learned Counsel, appearing on instruction of Miss R. Chaudhary, Learned Counsel for the petitioners. Full stop. Also heard Sri D. Mazumdar, Learned Additional Advocate General for the state respondents, assisted by
S. Nath.
S. Nath. Nath, Miss S. Nath. And private respondents, anybody? Private respondents? Respondent number 2. Only one private respondent has contested. Sir, what is your name? N. Kakoti. N. Kakoti, Learned Counsel, appearing on instruction of Sri S.C. Kyle for the respondent number 4. 4. Para. Please have your seat, madam. The issue involved in this case pertains to a challenge to an order dated 8/9/2020 by which the services of the petitioners as assistant government pleader in various foreigners tribunals at Dhubri were terminated. Full stop. Para. The Learned Counsel for the petitioners has submitted that the petitioners were duly appointed via an order dated 2/3/2016 issued by the Home and Political Department for various districts of the state. Full stop. In the said notification, comma, under serial number 11, comma, the district of Dhubri, the appointments made in the district of Dhubri have been stated, in which the names of the petitioners figure. Full stop. It is submitted that pursuant to such appointment, comma, the petitioners were discharging their service diligently and without any blemish. Full stop. However, by the impugned order of termination dated 8/9/2020, comma, by the impugned order dated 8/9/2020, comma, the petitioners have been terminated from their service. Full stop. It is submitted that no notice whatsoever was issued to the petitioners prior to such termination order, and no reasons have been assigned for such termination. Full stop. The Learned Counsel accordingly submits that appropriate orders be passed for setting aside the termination orders and directing to continue the services of the petitioners. Full stop. Para. Per contra, comma, Sri Mazumdar, the Learned AAG, has submitted that the appointment was purely on the doctrine of pleasure. Full stop. It is submitted, and by referring to the communication dated 26/11/2015, comma, the Learned Senior Counsel has submitted that that recommendations were sought for from the Deputy Commissioner of names to be appointed as Assistant GP. And based on such recommendation, the appointments were made. Full stop. The Learned Senior Counsel has also submitted that though the appointment order did not specify the duration of such appointment, comma, there is a specific mention that the appointment should be governed by the concerned office, concerned notifications. Full stop. In this regard, comma, reference has been made to the notification dated 27/6/2013, holding the field, as per which appointment oblique engagement of government advocates would be for 1 year, which would be renewable. Full stop. He submits that the petitioners had already served for about 4 to 5 years, and only to give the other advocates a fair opportunity, comma, the said step has been taken. Full stop. He has also clarified that though the expression termination has been used, comma, the same is actually a discontinuation without any stigma. Full stop. Para. Ms. Jaman, the learned counsel for the petitioners, has also fairly submitted that the petitioners were also having the knowledge that the initial appointment was for a period of 2 years. 2 years. And the said period was over long back. Full stop. Para. The impugned order dated 8/9/2020 has no doubt used the expression termination. Full stop. However, such termination cannot be said to be stigmatic in nature, as it appears that it is a termination simpliciter, which, in other words, is a discontinuation of service. Full stop. The impugned order also contains certain appointments of new persons to act as assistant government pleaders in the said post. Full stop. The initial appointments of the petitioners being only by recommendation and not through a rigorous process of recruitment, comma, the petitioners would not have an indefeasible right to continue with such appointment, that too as assistant government pleaders. Full stop. After all, comma, the government who appoints its council would have to be given liberty to have their council of their choice, and nobody can force the government to make him or her a government council. Full stop. Para. In view of the aforesaid facts and circumstances, comma, this court is of the opinion that no case for interference is made out. Full stop. And made out, and accordingly, the writ petition is dismissed.
May I please? Okay, kindly pass over the matter for the day. My senior is out of the.
Mr. Dutta was waiting for the morning. You should have told him. Who is appearing?
Mr. J.K. Goswami. Standing.
Mr.
J.K. Goswami.
J.K. Goswami.
He's out of the.
Matter of which year? 21. Okay, we'll grant a date. But you should tell him in advance. Senior counsel waiting. Why are you unnecessarily? Okay. Do Sri S. Dutta, senior counsel, is present for the petitioner, comma. A prayer for adjournment has been made on behalf of Sri J.K. Goswami, learned standing counsel. Apex Bank.
Effect.
Full stop. Para. Yes, tell us a date.
6th of August.
6th of August, is it okay?
Yes.
As requested list on 6th of August 2024.
Obliged.
Mr. Bushra?
My lord, this matter is pertaining to reservation in promotion. My lord. And my lord, the finance has filed their affidavit, my lord. I have filed the affidavit in reply yesterday, my lord.
It will be connected with equality forum case also.
Yes, sir.
And then this court will not take up this.
My lord.
We had appeared as counsel.
Here, my lord. Yes.
Please before any other bench without me.
My lord, interim order in both the matters, there are interim order.
Interim order passed earlier to continue till the next date of listing.
Oh, lord. Okay. Wait. Before your lordship, at employees of Himanta Sakateo Kalakata Society. They are brought into under regular scale of pay, my lord. And but they have not entered get the pensionary benefit after retirement. So similarly situated.
Who is appearing? Mr. Bora?
I appear only for respondent one. Sankote Kalaketra is the own standing council.
Mr. Goswami is the standing counsel.
Yes, Kalaketra.
Mr. Goswami is not there today, some difficulty. Will have been on 6th of August? Is it okay? 6th August? Those three, Boragohan, Learned Counsel for the petitioner, as well as Sri D. Bora, Learned State Council, are present, a prayer for adjournment has been made on behalf of Sri S.C. Goswami, J.K. Goswami, J.K. Goswami, Standing Council, Konkodev Kalakshetra, puts the para, as requested, list on 6th of August. Same date, both the matters.
16. In this case, we are filing affidavit today for my.
PNB.
Lord, there is a peremptory order, my lord, that we do not file hospital post, my lord. We are filing today. I'll give the copy.
Okay. Okay. Sri A. Ganguly, Learned Counsel for the petitioner, for the respondent PNB, submits that the affidavit in opposition is being filed today in terms of the liberty granted by the court on the last occasion. Full stop para. Let this matter be listed on Friday of Monday next, along with the affidavit that would be filed during the course of the day.
Clear. Public.
17.
May it please your lordship. Madam, in this case, petitioner completed 30 years of qualifying service on 26/2/2019.
For MSCP.
MSc. He is denied, my lord. Kindly see, my lord. Annexure 3, page 14.
Reasons.
SCR, my lord. It is not communicated. Uncommunicated SCR, my lord. In their affidavit, they have clearly stated, my lord. Kindly see page 30, my lord. Para 12.
Tell us the facts.
My lord.
Tell us the facts, basic facts.
Basic facts, my lord. Petitioner was appointed in the year, my lord. 26/2/89, my lord.
As
as my lord rifleman.
General literate.
Then my lord, in 26/1/2003, my lord, he was
20?
26/1/2003.
Yes,
He was promoted to the post of Havildar.
yes.
Then my lord, in the year 2012, he was promoted to the post of warrant officer.
Hmm.
He is presently holding the same post, my lord. And on 26/2/2019, he has completed 30 years of qualifying.
When?
26/2/2019.
30 years completed.
Then my lord. Then my lord, he was not given MSP benefit. He has filed one representation. Kindly see Annexure 1, page 12.
Page 12,
12 my lord, of representation.
dated?
Date, my lord, date is not clear, my lord. Then my lord, Annexure 2, page 13, it was forwarded.
Page?
Page 13, my lord, Annexure 2. A representation was forwarded on 5 November 2021.
5th of November 21. Representation forwarded.
Then Annexure 3, page 14, last annexure, reply to the application that, may I read, my lord?
Yes, please.
It is intimated that number 7 for Runu Mukherjee have been awarded average grading during the year 2017. Same has been justified in pen picture of the individual. As per para 37 of ROI 597, individual not required to be communicated to the individual in writing, and no warning letter is to be given to the above grading. Due to above, it is lacking SCR criteria of third MSCP, individual to be indicated accordingly. They have said that it is not necessary for communication. But as per Supreme Court, my lord, as well as our High Court's order is also with me, my lord, it must be communicated. That is my simple case, my lord. In 2019, I have completed 30 years. In their affidavit, they have clearly stated that we have not communicated because it is not necessary. That is their statement.
No, madam, let us come to the substantial relief which we are thinking about.
My lord.
Suppose we set aside this order
Right.
and the ACRs, we hold that it was required to be communicated
My lord.
so that you get a chance
My lord.
to
Represent.
not only to represent or to improve, whatever. Now, what effective relief will you get here?
So if, my lord, I am getting the chance and I am updated, my lord, then I may be given from that date, my lord, from the date on which I am eligible.
My instruction this morning is retired old, my lord.
No, even if she's retired, she can she can make a representation regarding trying to convince the authorities that there is a scope to give better gradings, and in case you are
So far, my lord, the
he or she
page, my lord, 89, my lord, it is there, my lord, page 9.
petitioner is a lady
My lord,
or lady or what?
my lord,
Petitioner is a lady or what?
my no, not
No.
lady,
Runu naam?
my name is Runu.
He, my
He.
Runu. Okay. He'll get a chance
my lord.
because Devdutt, Sukhdev, all the cases are there. What cases have you?
My lord.
Devdutt,
Devdutt, then my lord,
Sukhdev,
Sukhdev, then my lord, very recent judgment of Supreme Court, my lord.
which
It
one?
is of 2023, my lord, RTS Dipon Lota.
You have copies?
Yes,
Please hand it over. Mr. Medhi, when did he retire?
My lord, date is not, my lord, but today, my lord, just today.
Roundabout, madam, when did you retire? Any idea?
requirement that my lord,
Any idea which year?
I declare, my lord, kindly see the age. Who knows the date? No, my lord, I do not think so that he has retired. He has not informed me.
What was the age at the time of
Yes,
filing?
my lord, at the time of filing 54, in 2022, my lord, I have filed
What is your age? What is the age of
60, my lord.
60? It's a normal age, not
No.
short service, nothing like that. 60, then I think he's still in service.
Yes, my lord. That is another aspect, my lord. He has filed a PDP in opposition in 2022, my lord.
Hmm.
So now, my lord, matter is 80, my covered case, my lord, unnecessary pending. My humble
No,
submission.
we are disposing of this
My
matter.
lord.
But this factual position, we should be very clear. If he's retired, our
No,
direction
my
should
lord, I
be.
do not think so. 54 years in 2022. And he has not informed me also till today. Till now.
Let us come on Friday, madam.
We'll have it at 2 o'clock.
2 o'clock.
2 o'clock. Have a telephonic instruction
Yes,
whether he's
yes.
there on service.
Yes.
Madam, you also try to contact your client.
Yes.
You also try to contact.
Then, my lord, on Friday, second half, I have some difficulty.
No, today, second half, difficulty.
Second.
Friday.
But I have the instruction, my lord. He has
Come
not,
at 12:30.
my lord,
12:30.
my lord.
Well, finish off these matters. You make those copies ready. So Devdutt, Sukhdev and the last 2023 matter.
My-
একটু দিব লাগিব হ্যাঁ 12:30 একটু হেক কৰি দিম আৰু
Arthur also on left side. Arthur also, my lord.
Arthur, he is on late in 4.5.
What is the matter?
Matter, my lord, regarding my lord non-payment of pensionary benefit, my lord.
Pension.
Other of the petitioner, my lord, serving as.
He was here, just that he was called to court now 5.
Okay, we'll have it on Friday.
My lord.
Okay. On Friday, Mr. Sharma. On a prayer made on behalf of Sri R. Dhar, Learned Standing Council PWD, matter is adjourned to be listed on Friday. Okay. Okay, Sri D. Bora, Learned State Council, and Sri B. Sharma, Learned Standing Council AG Assam are present. Upor likhe petition is represented by Sri K.R. Patgir.
Lordship, we have received the instruction, your lordship. Lordship, which time may be given to file our affidavit, your lordship.
You are for the PNRD?
PNRD, lord.
Okay. Ms. J. Bora, Learned Council appearing on instruction of S. Datta,
Lordship, on
As
behalf of
the-
S. Datta.
Standing Council PNRD submits that instructions have been received and the affidavit would be filed soon, full stop. See accordingly prays and is granted 2 weeks time
Sir.
to file the affidavit in opposition, full stop. Sri D. Bhattacharya, Learned Standing Council AG Assam is present.
I'm approved.
Yes.
Maybe Lordship. In this matter, regarding promotion, Lordship. There are two petitioners, the difference of the.
Mr. Barua, who will be appearing? Who will be appearing? B. Gogoi. Where is he? Can he start? In the meantime, he'll come or we'll have at 2 o'clock. Can this, Mr. Kokote, can this be disposed of?
It can be Lordship. A file.
My lord, we have filed our affidavit in opposition.
Okay, let Mr. Gogoi come, wait for a while.
Lordship.
My lord.
এটা হলো বেলিক আহিলে দিয়ে দিবেন
Please, Lordship, there is some lag, where we take up some time, Lord.
What is the matter?
Okay, my senior is also.
Ardhar,
Yes, sir.
on Friday or Monday?
Friday, Monday.
Friday or Monday? Monday.
Monday.
Monday, on a joint prayer, on a joint prayer made by the parties, list on Monday.
Obliged.
Learned counsel for the parties. Learned counsel for the parties.
22. They are there.
22. There's a prayer from both the sides. So Monday we'll be having. Okay.
Not finally. Came up before. Also, while on several occasions, just a hard time. So
Monday will, if you are there, we'll have
Admission
it
here.
Monday. Don't worry.
Admission here.
Admission here. Item number 22. Madam, you are appearing.
Yes, my lord.
Lordship, we need to file an affidavit, Lordship, and
Okay. The Industries and Commerce Department, there is a prayer on behalf of the Industries and Commerce Department for grant of time to file affidavit in opposition, full stop. As time was earlier granted, comma. A final opportunity of 3 further weeks is granted to file the affidavit in opposition. File it in 3 weeks. Don't take so much of time.
obliged.
23.
My lord, in this case also petitioner is not given promotion because of
SGC, Mr. Chakraborty.
lacking of SCR that is uncommunicated.
Uncommunicated SCR.
Our sense is this is not uncommunicated, it's lacking a real lot.
What is your stand?
We are unable to be promoted. Because following the 2007 7 pay commission lottery, the grading has been upgraded to, from good to very good. And for that 4 high average or average 3, that has to be accurate. But in his case, lottery, in the last 2, ACR there was 2.
But did
That's
you
why-
did you communicate the ACR?
No, it is not a case of,
Now, did you communicate?
no, it is not okay, adverse. It's not a case of any adverse.
Even non-adverse, even good has to be communicated.
Lottery where and is the OM lottery may come to page
Now
87.
you have read Devdutt, why should we again reiterate?
Lordship,
Whatever is the ACR, you have to communicate.
there is lordship one case in which the Supreme Court has stated that he can file a representation that can be.
Now, Mr. Chakraborty, if it boils down to the fact that ultimately it is on the base, it is based on the gradings that the promotion has been denied, then the question will come whether he had communicated the gradings. If the answer is no,
Lordship, in the
then
case of-
you have to reconsider.
Lordship, in the case of promotion, all other, not only the SCR, other aspects has.
No, you consider the other aspects. We are not saying that, we are not saying that only based on the ACR that you have to promote.
Let him file a one representation.
Yes,
for
yes, that
lordship
is,
and
that
that
is,
can be the-
that is it. What has been said here in Anil Kumar?
Lordship.
In the case
In
of,
this case, the representation has to be filed and that has to be considered.
that we are,
Paragraph 2021.
no, we cannot direct promotion. We can direct a consideration of promotion in accordance with law. That's all. Madam, basic facts. Facts. Okay, doesn't matter, not required. Look. The grievance raised in this petition filed under Article 226 of the Constitution of India is pertaining to denial of promotion. Full stop. The primary contention is that such denial is on the basis of certain gradings in the ACRs. Do you still call it ACR or APR? ACRs. ACRs, which according to the petitioner were not communicated.
In their affidavit, they have said that page 36.
Okay. Para. I've heard Ms. S. Bora, learned counsel for the petitioner. Full stop. I have also heard Sri B. Chakraborty, learned CGC, who has also filed affidavit in opposition on 11/10/2023. Full stop. Anyone else? No response. Vera. Ms. Bora, the learned counsel has submitted that the petitioner was initially enrolled as a rifleman within bracket GD in the Assam Rifles on 6/7/1992. Full stop. The petitioner claims to be belonging to the scheduled caste category. Full stop. He was promoted to the rank of Havildar GD on 1st of May.
Yes.
1/5/2004, and thereafter promoted to the rank of warrant officer within bracket GD on 15/7/2012. Full stop. A promotional exercise was done, which culminated in an order dated 29/3/2021, in which the petitioner was not promoted, in which the name of the petitioner did not figure. Full stop. It is the grievance of the petitioner that persons junior to him were given the benefit of promotions, leaving out the petitioner. Full stop. Para. The specific case of the petitioner, as contended by the learned counsel, is that the promotions were based on the gradings of the ACRs, and such gradings were not communicated. Full stop. It is submitted that communication of the gradings in ACR is a mandatory requirement and a legal obligation by which, the government servant, the employee gets an opportunity to file representation for upgrading the gradings as well as to improve his performance. Full stop. The learned counsel has also submitted that in the affidavit in opposition, the aforesaid aspect has been admitted. Full stop.
It's not accepted.
The learned counsel has relied upon the following decisions on the aspect of the requirement to communicate the gradings of ACRs. 3 decisions, huh? 1, 2, 3, the bottom. Para. Per contra, Sri Chakraborty, the learned CGC, has submitted that there is no admission in the affidavit in opposition, and the promotion is not dependent on the ACR gradings alone. Full stop. He submits that the petitioners, the gradings of the ACRs of the petitioner were upgraded. Upgraded, you said? Upgraded. And therefore, the same would not be the sole reason for the impugned action. Full stop. He submits that the promotions to the other incumbents were done by following the
Because Lordship, one senior to him also not been promoted.
by following the procedure established in law and in a fair manner, and none of the promoted candidates have been made parties. Full stop. He has also highlighted the aspect that it is not only the petitioner, but even persons senior to him in the gradation list
Page 48 was
who
added
has
the
been
list, Lordship.
who has been denied appointment in the exercise performed. Full stop. Para. The rival submissions have been duly considered. Full stop. Para. Our promotion is dependent on various factors, out of which the gradings in the ACRs is one of the prominent factors. Full stop. That brings us to the aspect of the importance of such gradings and the obligation, legal obligation of the employer to communicate the gradings in terms of the settled law. Full stop. The materials on record, however, do not indicate that the gradings were communicated to the petitioner. Full stop. As full stop. In view of the above, comma, this court is of the considered opinion that the petitioners be given a chance to submit adequate representation on the aforesaid gradings of the ACRs so as to convince the employer to make a higher grading. Full stop. Accordingly, comma, at the same time, comma, this court also observes, this court, comma, as observed above, also records that the other aspects for promotion are also to be taken into consideration by the employer. Full stop. Para. In view of the aforesaid discussions, comma, the writ petition is disposed of by giving liberty to the petitioner to submit a representation on those gradings of the ACRs which, according to the petitioner, is not as per his performance. Full stop. Such representation may be filed within a period of. Can you do it? 15 days, okay. Within a period of 15 days from today, and on submission of such representation, comma, the same is directed to be considered and disposed of by a reasoned speaking order, which is required to be communicated to the petitioner. Full stop. The respondents are also directed to take consequential action in case the representation is favorably considered and consider and accordingly make favorably considered. Writ petition is disposed of. If you upgrade, then you apply for reconsider for her. Madam, those decisions.
My lord, my 2022, my lord, 1st August retired.
Then how was it possible? 54 years.
My lord, earlier it was 30 years of service like this. That is my year. So
Then we can have this matter.
my lord,
We can have this disposal.
Well,
So, way to ask it.
Article number 17. Only that is our stand is, my lord, is so far this memorandum is there, page, my lord, 84, 89, man. Here's one paragraph, my lord, mentioned, my lord. ACR will not be shown to the NCO concerned. The adverse remark, weak points, and the below average assessment inequality will be communicated in writing, man. Only this, as per this, our contention, it is not adverse. So you have not communicated.
No, even adverse or
No,
anything,
just-
everything has to be
yes,
communicated.
Done.
The ACRs as such need not be disclosed to her, but the gradings have to be communicated.
But only my permission may be recorded, my lord, and your lordship.
Okay. This will be similar, I think,
Similar.
but this is for MSCP,
MSCP.
not for promotion.
Yes.
No.
Okay.
MSCP 3.
You लिख दिया. Retired when?
My lord, 1st August 2020. 2020. This is my delivering instruction.
No, she has also endorsed. আমার যে আরম্ভণের যে আগৰটো for promotion আছিল, এইটো not for not giving the third MSCP.
Yes.
Third MSCP on completion of 30 years. We'll dispose of in the same length.
Yes,
We'll
yes.
on that order we'll make some notification
yes.
and we'll have those same case laws. এইটো নিচিনা হ'ব, মই অলপ change কৰি দিম.
Yeah.
Factual change হ'ব আৰু SKM এদি থাকিব এটা.
My lord.
Dispose of.
Item 25.
Here the petitioner has filed a reply, lordship, but in my copy, lordship, page 192 is incomplete, lordship. So I think
Okay.
they have to furnish
That
me a
was disposal,
page
huh?
80, lordship.
একেলগে থৈ দিবা, খালি note to leave. Yes. You give a better copy.
Mistake. Next year, Tuesday.
Thursday.
When?
Hello, 1st of August, my lord.
You are also there.
I am the petitioner, my lord.
Okay. Sri D. Upamanyu, Learned Standing Council, Health and Family Welfare Department has submitted that though a copy of the affidavit in opposition,
Reply.
rejoinder affidavit has been served upon him, comma, the same appears to be incomplete. Full stop. Sri Decca, Learned Counsel for the petitioner undertakes to serve a complete copy
Today.
during the course of the day itself. Full stop. Para. As requested, list on
1st of August. Thursday.
1st of August is okay? Okay. Now 1st of August is Thursday. Why Thursday?
Lordship, can it be on 5th of August?
5th of August. 5th.
Highly obliged.
Item 26.
Lordship, I have received the instructions.
Yes.
Here, the process of providing the pension has been initiated. The petitioner has been called up to sign on the pension paper. And if goes and signs the pension papers, then they will forward it to the authorities.
This is item number?
26. The last petition, can you see the order 26?
So now you advise your client to go to the office and sign whatever is necessary.
But I think that process is over. That this is
No,
the
he has the
latest I have
instructions.
received today.
When did you take the last instruction?
20th November,
When did you take the last instruction?
it is earlier than.
No, you take instruction. Okay, and advise your client. Sri D. Bora, Learned State Council has submitted that as per instructions received, comma, the process of the exercise to process the pension is on, and the petitioner is required to put her signature
Police reserve Tezpur.
in the police reserve,
Yes.
Tezpur. You belong to Tezpur?
No, but
Then
the petitioner belongs under Dhubri.
Dhubri.
He was service there is perfect.
Then why do you call her to Tezpur?
That's what the written instruction said. The WT message has been sent to the OC, Bilasipura, Dhubri, district to inform the petitioner.
No, but if she comes to Tezpur, but you completed it in one day, don't you instruct your clients? she comes, the officer is not there, then she will be in unnecessary difficulty. You are a widow.
Lordship not. His husband is alive, Lordship. He is mentally.
Okay, okay. No, no, she's in distress, so you take care. Okay. কি করলে? হ্যাঁ? কি করলো রাস্তাটা? Put her signature in the documents at the police reserve, Tejpur. What's the para? Anything?
Otherwise, your Lordship may observe that the pension papers may send to her considering the condition of the.
Okay. Yes, that is a good suggestion. Para. Srinath, the learned counsel for the petitioner, has however informed this court that the petitioner has a residence at Dhubri and the pension is on account of her husband who is suffering from mental ailment. Full stop. Para. Considering the aforesaid aspect, the respondent authorities are directed to send the required documents where the signature of the petitioner is required to the petitioner by either by special messenger or by a special messenger by involving the local police station. By involving the jurisdictional police station, namely Bilasipara police station. Full stop. After obtaining the said signatures, the papers may be routed back to the respondent authorities,
Assam Police Headquarters.
to the Assam Police Headquarters through the let the same exercise be done and completed within a period of 3 weeks from today. Is it okay? From 4 weeks from today.
4 weeks.
Full stop. Let this matter be listed after 6 weeks, on which date Sri Bora would apprise the court of the up-to-date status.
Problem.
Yes.
In this case, notice was issued, my lord. They have to file affidavit, my lord.
Lordship, on the last occasion, they had filed an IA, wherein, my lord, that has, for implement, the publication was done. So that, my lord,
No.
You have filed
IA for modification, that was, my lord.
no,
There is
I for
application.
amended cost title, have you filed?
Yes.
You have filed already?
Yes.
my lord, I am awaiting instruction, my lord, so some time may be given.
Okay. You are Kolita?
Yes.
M. Kolita?
Yes.
Sri M. Kolita Learned Counsel for the petitioner submits that amended cost title has been filed in the meantime. What's the para? Sri A. Fukan.
My lord,
You for?
I'm for the respondents 1, 2, and 3, my lord.
Which one? Standing counsel
Standing counsel, my lord,
Of-
general GAD.
or standing counsel
For 1, 2, and 3.
GAD. However, no, submits that instructions are awaited.
Oh.
Full stop. He prays for and is accordingly granted 3 weeks time to obtain the instructions, file affidavit in opposition. Did you take steps on the newly included respondents?
Yes, my lord.
When?
As per office notice, my lord, notice was served.
Notice has been served? Okay.
They are for admission column.
Received it.
Yes, item 30.
This matter related to non-payment of pensionary benefits.
Yes, who's for pension department, Ms. Hazarika? Yes, Madam Kolita, you are appearing for which department? PHE? Pension, who will take care of pension? Department or forest department? Who has the role, forest department or you?
Lordship, we are not denying the right of the petitioners to claim the pensionary benefit. The only issue is that there is no provision for division of pensionary benefits. in the pension rule. We have received,
They are praying for division.
Our one concern was that, my lord, while after the death of the father of the petitioner, we had submitted our NOK, the daughter, minor daughter, and the main thing is that
You are the son of the, who are you?
I'm the daughter. I have another minor son.
You are the daughter of the deceased.
Yes, daughter of the deceased, as well as the
And-
first wife. Well,
Huh?
after the death of my mother, so my father had married his second wife.
You are
and
the
they-
daughter of the first
Yes,
wife.
the daughter of the first wife. Daughter and my son, the elder one. We both are the biological children of the first wife.
You are two petitioners,
Yes, two people,
son and daughter.
son and daughter. After
presently, your lordship, the second wife is getting the pension.
second wife is getting the pension, and
Who's representing the second wife? You are there.
For respondent number 12.
R12 is the second wife.
Yes.
Okay.
I am willing to pay their share. But the matter, paternal uncle of the petitioner, to state the matter, sir. Their contention is that I have tipped 6,72,000. This is false, sir. The department charged to me only 2,70,000. And I expend this money, about 2,10,000, for the purpose of start-up for my house.
See, what is your name?
SS Ahmed.
SS?
SS Ahmed.
Mr. Ahmed. See, the matters of apportionment, we cannot look into it. But the ideal recourse is to send you to the civil court. But to shorten down the litigation process, if, what is your name? Mr. Ahmed, what is he suggesting? That he is not averse to the proposition of distributing the pensionary benefits. If you are agreeable, then you can enter into an agreement, give it to the department, sort out the matter.
I am always ready, method. That's that.
And in our rejoinder, my lord, we have already claimed that 2,70,000 they have maybe adjusted, my lord, may our share because
No, best is to sit and talk. And he has fairly said that it can be adjusted, it can be.
that was in our rejoinder also have placed that like it be adjusted.
Exactly, that was what we're thinking. We send it to the mediation. Where does your client stay? In Guwahati?
No, she stays in Kokrajhar.
And your client? Okay. We have it in the Guwahati High Court premises, okay? The matter pertains to a claim, oblique apportionment of the pension and other benefits on the of a deceased government servant who had worked as assistant conservator forest with the forest department. Full stop. Para. I have heard Sri S. Ahmed.
SS Ahmed.
SS Ahmed, learned counsel for the petitioner. Miss M. Kulita, learned standing counsel forest department. Sri R.K. Talukdar, standing counsel, AG Assam, and Sri M. Ahmed, learned counsel for the respondent number 12. Full stop. Para. Sri M. Ahmed, learned counsel for the respondent number 12, submits that his client is agreeable to an order of apportionment. Full stop. However, there appears to be some dispute with regard to the initial amount claimed to have been received by the respondent number 12. Full stop. Para. Considering the nature of the dispute, this court is of the opinion that an attempt be made for resolution of the dispute by means of mediation. Full stop. Para. The matter is accordingly referred for mediation. Full stop. Yes, card you name mediator. Mediator, कौन है? Oh. এটা নাম আছে নহয়? এইকেইটা আৰু কোন আছে? N Bharali আছে নেকি? Nandita Bharali. We'll give the name. Okay. And we'll intimate who is the mediator. Kindly inform. It can be either N Barua or N Bharali. Huh? Salu. Is appointed as the mediator to mediator, full stop. The learned council, the learned council, the parties through the learned council may furnish all the necessary documents to the learned mediator who would hold a sitting in the premises of this court within a period of 3 weeks from today. Full stop. Let the mediator furnish a preliminary report on the next date, depending upon which further order would be passed. Full stop. List this matter on on 23rd বন্ধ নেকি? On 28th of 28 of August, on which date the report may be placed before this court through the registry.
I'm obliged.
Okay.
Item 31.
Yes.
In this case, respondent file an affidavit to file it private process. Sometimes
Who's for the respondent? Respondent is the bank.
Our affidavit, we had filed on 28th of June. There is some defect I found by the registry. Correct it, not will place it.
But defect, is it substantial?
No, only that mobile number of the signing officer was not.
Oh, that is okay. But you correct in his
Yes,
the
no,
copy which is served to him. Sri A. Ganguly, learned counsel for the respondent bank, has submitted that the affidavit in opposition has been filed on
28/6.
28/6.
What was returned by the
28/6 was presented for filing on 28/6/2024 by serving a copy to the learned counsel for the petitioner. Full stop. The learned counsel has also submitted that there is some minor defect in the affidavit pertaining to a mobile number of the concerned officer, which is being corrected. Full stop. Sri L. Mohan, learned counsel for the petitioner, acknowledges receipt of a copy of the said affidavit in opposition and prays for some time to file rejoinder affidavit. Full stop. Para. List after 3 weeks for filing rejoinder. Full stop. In the meantime, comma, the defects may be rectified in the affidavit in opposition and the same be tagged with the records of the case. 3 weeks, we file it, we'll see it. What is the matter?
payment of my area salary record.
You are in service?
No, now I retired.
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 List will give a date. Retired person. List on. You filed it in 3 weeks, Mr. Mohan. 19th August.
It can be on 21.
21st. Okay, 21st of August.
Item 23.
I don't know. Hello.
Just a minute, just a minute.
I may be given.
Just to give us 2 minutes. ওকে আমি সাইকেলাই দিই এখন কেতিয়া ওলাইছে এখন লাস্ট নেকি লেটেস্ট নেকি না না প্লিজ টু ইম্পেন্ডেন্ট ফেলো আচ্ছা 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 এখন লেটেস্ট হবে আচ্ছা এখন গন্ডগোল সবক চিনি পোৱা নেকি হাইকোৰ্টৰ এটাও ধৰণ হাইকোৰ্টৰ এটা হ'ব দে য়েছ
Relating to my lord, overseas service product, one year, my lord.
matter 24 matter we filed you're for education department
Lord, I am for 1, 5 and 6.
Part 3A Khanicore Learned Counsel for the petitioner who submits that the matter pertains to overstay in service. Puts the para. Sri N. Upadhyay, Learned Standing Counsel Irrigation Department. Prays for and is granted further 3 weeks time to file the affidavit in opposition. Sri D. Bhattacharya, Learned Standing Counsel AG Assam is present.
All right, Lord.
Okay.
Diploma.
Yes.
My lord, in this case, we have challenged the order of the DP, my lord, whereby my service has been.
Yes, your affidavit records.
My lord, affidavit, we have not received the instruction.
Get the instructions.
Records probably were not called for.
No, you get the records, DP. We'll check the records.
Yes, my lord.
Okay.
One information we have received, my lord, the department is going to advertise the post, including the post which I was holding, my lord. So, my lord, my humble prayer, my lord, at least one post should not be.
Retirement, my lord.
Dismissal.
Yes,
Compulsory retirement.
compulsory retirement, my lord, he's out of the post.
We cannot.
And at my lord, his age to get.
What are your grounds of challenge?
Grounds, my lord, similarly situated other candidates have also been, my lord, what happened, they have been given only one increment deduction, my lord.
What are your grounds of challenge? What is the misconduct?
Some misconduct is, my lord, it's under PC Act, my lord.
PC Act?
Yes,
Accepting bribery, my lord.
that is there.
And his basic ground is for negative equality. Two other persons, my lord, they have not been imposed major penalty, so he should not be.
Mainly, my lord,
You get the records.
Yes, my lord.
Okay.
Your lordship may indicate in the order. I will get.
Sri, Hard Sri, Purcaster, B. Purcaster, Learned Counsel for the petition. Para, Sri DP Bora, Learned Standing Counsel, Health and Family Welfare Department, submits that instructions are still awaited. Full stop. Para, let this matter be listed after 3 weeks to enable Sri Bora, the Learned Standing Counsel, to obtain the instructions as well as the records pertaining to the disciplinary proceeding.
Obliged, my lord.
Item 27.
May I please, Lordship? Non-payment of the pensionary benefit, Lordship.
Yes, who is there? Pension.
My lord, we'll just peruse this annexure, page 28, my lord, of writ petition. We have done our part, my lord. Now it is AG, my lord, why they are holding it?
Yes, Mr. AG.
Page 28 is my lord peruses.
What is your instruction, Mr. Gogoi? Any instructions? Mr. Taludar, you are appearing. Who is appearing? Yes, yes. Come. What do you say, page 28? It's lying with you. Pension matter.
If they have rejected even, my lord, we don't.
What instructions? Get the instructions, pension matter.
Yes, sir.
And this communication is of 19. You must have taken some action. You must have, even a rejection order has to be communicated. Then at least petitioner can put to challenge.
Lord.
You retired as what?
Lordship, 2017, Lordship.
As
Master Lordship,
master roll worker.
Master Olga, thereafter he was regularized, Lordship. 39, 2025, 2005, Lordship.
Regular as master roll worker.
Yes.
Yes, then he'll be getting. And since his proposal has been sent by the department. Okay. Heard Sri P.K. Gogoi Learned Counsel for the petitioner who submits that the issue pertains to a claim of pension. Full stop para. Sri R. Dhor, Learned Standing Counsel PWD, by referring to the Annexure 8, which is a communication dated 2/3/2019, has submitted that the department has forwarded the pension papers to the AG Assam. Full stop para. Sri R.K. Talukdar, Standing Counsel AG Assam, submits that he is yet to be furnished with the instructions. Full stop para. Considering that the matter pertains to pension, comma, let instructions be obtained expeditiously by Sri Talukdar on the onward action taken on the communication dated 2/3/2019. Full stop para. List on. Yes, when? We'll have it on 7th of August.
7th.
Yes.
Highly obliged, sir.
Item 57, something is.
Yes, APDCL, Mr. Bordeloy, PG, yes. Yes, your matter. 57.
APDCL Lordship.
Yes.
Lordship, this is a covered case, Lordship.
Who is for the APDCL?
And Lordship, number of people which have been earlier disposed of, they have also been given some financial assistance as per their experience.
Okay. That regularization part and financial enhancement part.
Yes.
SAHACs.
Yes, sir.
We have decided many matters. They have taken a decision to give you financial enhancement,
Yes,
but the aspect of regulation has been negated.
Yes, sir.
Have you got financial enhancement?
Till that, not.
Who is appearing?
On the basis of the earlier decided cases, those some of those petitioners have got it.
Wait for a while. Let somebody from APDCL come. There are a number of council.
I will inform if I.
After a while. We can dispose this of perhaps.
Yes. Item 58.
Mr. Bora, what is this?
Your Lordship, the matter as such involves on a very narrow compass based on the Janakiraman judgment, wherein the three conditions were laid down in the Janakiraman judgment as to whether on
Still cover.
Still cover, and as to whether on the date of DPC there was any suspension order, whether there was any charge memo, or whether there is any.
Mr. Medhi, you have filed affidavit.
I filed affidavit, but it is not covered by the Janakiraman.
Even then also, Anil Kumar Sarkar also covered.
My lord,
Why?
I'll
come to that.
I have filed an IA, my lord. In this case, my lord, to bring some the record, my lord. This IA report is not good. My lord, this matter is already, my lord, is in IA, my lord. In it,
IA for what?
IA for some, I already filed a in opposition, my lord. After this, honorable court, my lord, already directed to file, if necessary to file IA, my lord. I filed for this. Bring the record.
No such direction. They
No,
could have
no, no,
actually
sir,
sought
no, sir.
leave from this court to file an additional affidavit, which they did not.
You couldn't file an additional affidavit.
Yes.
Why IA is necessary?
This is just a dilly-dallying tactic.
You,
Nothing else.
Mr. Medhi, you just you make this IA in the format of an affidavit, file it within a week.
Yes, sir.
You have the same documents
Yes,
if you are relying upon.
Yes.
Otherwise, matter we can
Yes, ma'am.
dispose this of.
Yes, my lord.
Otherwise, your Lordship.
IA is not necessary.
I'll.
Otherwise, also on the federal law aspect, your Lordship.
All this matter is
whole
not.
matter is-
Mr. Medhi, what are these documents you are trying to rely?
My lord,
Because Bora is trying to insist that this may not be necessary, we can
Yes, no, my
decide.
lord, no, my lord. My lord, we are not in delay practice also, my lord. He submitted last occasion also, my lord. This IA,
Okay, okay. How Sri D. Bora, Learned Counsel for the petitioner, who submits that the matter would be covered by the case of the Honorable Supreme Court of Janaki Raman versus
Your Lordship, NV, Union of India versus KV Janaki Raman,
Union UOI versus Union of India versus KV Janaki Raman reported in
AR 1991 SC 2010.
AR 1991 SC 2010
And also,
and Anil Kumar. Which
and
one?
also the judgment of Anil Kumar Sarkar, Union
And-
of India versus.
and as well as the judgment passed in the case of Anil Kumar Sarkar versus Union of India.
Union of India versus Anil
Union
Kumar
of India
Sarkar.
versus Anil Kumar Sarkar reported in
It's reported in 2013, 4 SCC 161.
2013 4 SCC 161. Para. Per contra, comma, Sri. No, don't say per contra. Sri SK Methi Leonard. CGC, however, disputes the aforesaid proposition.
Already, for the judgment of the apex right.
Footstep, para. Yeah, by drawing the attention of this court to the IA 2193 of 2024, comma, the learned CGC has submitted that the additional documents sought to be brought on record would have a material bearing in the decision-making process. Full stop. He has also refuted the submission that the IA has been filed only to delay the proceedings. Full stop. Para. In the considered opinion of this court, comma, instead of filing the IA, comma, the respondent authorities are required to file an additional affidavit for which leave is granted. File an additional affidavit to bring on records the said documents. Full stop. Leave is granted to file such additional affidavit, which however is to be done expeditiously and in any event within a period of 2 weeks from today.
Your Lordship, 2 weeks will be a high because already. it is
We'll
there.
fix a date. List on. But give him advance copy.
Yes,
Your
my
Lordship,
List
my
on.
right time to file within 1 week, Your Lordship.
I will
because
file within
everything-
1 week, my lord, then.
Okay, within 10 days.
10 days.
We know 1 week will not be done, then
Yes.
again we'll seek time.
Yes.
That is why, 10 days. List on 12th August.
Can it be on 13th of August, Your Lordship, Tuesday? In motion day, Your Lordship.
Motion days are okay, good, in fact. Hearing days will not reach if a hearing takes place. Have it on 12th, let's see. 12 August.
Your Lordship, may observe endeavor may be made to
Oh,
dispose
we'll
of the-
remember, don't worry. Yes, APDCL. Madam, just a minute. Madam Borman, just 1 minute.
He's claiming similar benefit which is granted to some other petitioners. So
Pay
personally,
enhancement you consider?
yes, Your Lord, he has to submit a representation to the Chief General Manager, HRA.
Any orders earlier?
Earlier order is already annexed to the petition, and this is what we have issued pursuant to those.
Number of people have also got some fixed economic package for this.
Already received. Oh, my lordship, I have been informed that he's already received.
Considered and received.
So considered and received.
Mr. Baudelaire?
Lot.
When
Yes, his
did you-
name is there, Lord.
Huh?
His name is there, Lord. 17,000 rupees per month,
Then we close this.
Lord.
Ah. Okay.
Not after.
Huh? Okay. Heard Sri PK Baudelaire, learned counsel for the petitioner. Also heard Sri KP Pathak, learned counsel APDCL. Full stop. The matter pertains to a claim for grant of economic package as well as regularization of service of the petitioner who claims to have requisite experience for the post of Sahayak. Full stop. It is submitted that there has been directions of this court to consider such cases of persons who had completed 10 years of continuous service. Full stop. It is also submitted that similar persons had got relief. Full stop. Para. Sri Pathak, the learned standing council, has however submitted that pursuant to directions of this court, comma, the matters were considered, and while the aspect of regularization of service was negated, comma, the pay upgradation was done. Full stop. He has also placed on record that, in fact, the case of the petitioner was amongst those candidates which was considered, and the petitioner was given an economic package. Full stop. He has placed on record a copy of the order dated 14/12/2023, in which the name of the petitioner figures against serial number
46.
46. What is your name? Shankar Jyoti.
Shankar Jyoti Sutia.
Full stop. Para. Peruse the said office order. Full stop. Para. It appears that the grievance of the petitioner has been redressed substantially. Full stop. Para. In view of the above, comma, this court is of the opinion that there is no reason to keep this writ petition pending, and accordingly, the same is disposed of. Full stop. Copy of the order dated 14/12/2023 is made part of the records. What is the other one?
The other one is the office order for constituting the committee to.
এটা লিখিবা ওপৰত। Sri Pathak has also informed that wide an office order dated 1/12 or 2/12? 2/12/2023, comma, a committee was constituted for considering such grievance. Yes, Madam Borman. Yes.
In this case, my lord, I have been newly engaged. My Kalatnama is not there.
Doesn't matter. What is the matter about?
My lord, petitioner, he was appointed as instructor, Industrial Training Institute.
Madam, you are for whom?
Mr. Asida,
You have filed your affidavit.
by today we are filing affidavit.
You will be filing today. Okay, let them file the affidavit.
A little amount is there only. That
Let them file the affidavit. It is the learned counsel appearing on behalf of the Labor and Employment Department, correct? Submits that the affidavit in opposition would be filed during the course of the day. Full stop. Let's a copy of the affidavit be served upon Ms. Borman, P. Borman, learned counsel for the petitioner. Full stop. Ms. Borman may also file the formal wakalatnama within a period of a week from today. Has also been served upon Ms. Borman, who appears on the basis of instructions.
So some process is going on.
Yes, yes, what is this?
So some process is going on.
Contempt matter 19.
2019 matter.
Your appeal has been dismissed. Comply with this. What is the
18/6/24.
what is the direction?
The direction is there, madam.
What is the direction?
Page number 22.
22.
Yes, my
What direction?
there was a order for creation of post for the
For the-
ITI Salakati.
There
28 numbers of post was created for the ITI Salakati.
When was the appeal dismissed, madam?
lordship, 18/6.
What is this?
Okay.
Lordship, there are 7 petitions, lordship. I think that out of 7, 3.
This court has been informed that the appeal preferred by the BTC pertaining to the order in question has been dismissed on 18/6/2024. And the full stop, Ms. R.B. Bora, Learned Counsel has submitted that steps are being taken for onward steps. No, for onward action. Full stop, para. List on an action and praise for 3 weeks time. Full stop. List after 3 weeks.
Any date may be given.
Okay. List on, don't say 3 weeks. List on 19th of August.
19th of
Come up with instructions, madam, regarding compliance.
Right.
Okay.
43.
May I please, Your Lordship? Lordship, in this matter, we are alleging violation of judgment dated 16/12.
Contempt matter.
Lordship.
Contempt. Yes, madam.
Lordship, we have forwarded the petitioner's name to the finance department.
Where is your affidavit?
No affidavit has been filed, madam. We have not filed our affidavit.
File the affidavits. Let the steps taken by you towards compliance be on record. Okay. And who's appearing here for respondent number?
Lordship, respondent.
Sole respondent.
Sole respondent, madam. Because it was the Commissioner Secretary PNRD who was directed to dispose of the representation by reason of
Heard Miss P. Agarwal.
Dr.
Learned
P.
Counsel. Yes.
Dr. P. Agarwal.
You're a doctor now. Heard Dr. P. Agarwal, Learned Counsel. It's not reflected in the cost
Lordship, because this matter is of 23 and the notification was just 2 months ago.
Okay. Heard Dr. P. Agarwal, Learned Counsel for the petitioner. Para. Ms. J. Bora, Learned Counsel, appearing for the sole respondent, submits that the proposal has been sent to the finance department. Full stop, para. Let these facts be put on record by way of an affidavit, which may be filed within a period of 3 weeks from today.
Lordship, 43, 44 and 45 are similar.
A respondent is the same.
Yes,
Same
sir.
instructions. Okay.
I'm obliged.
Eta order করে দিবা।
I received the service completed from all the respondents. Please, Your Lordship. Your Lordship, I am appearing on behalf of KK Deka and we are for respondent number 5. We require some time to file affidavit in opposition.
Okay. Others, who are the others, madam?
Mr. State, my Lordship.
Okay. What is your name?
M. Sahu.
No.
Dimi Rab.
J. Rabha.
Dimi Rab.
D. Ms. D. Rabha appears on instruction of Sri A.K. Deka.
KK Deka.
KK Deka, Learned Counsel for the respondent number 5. Full stop. C. Praised for and is granted 3 weeks time to file the affidavit in opposition. The state respondents may also file the affidavit in opposition in the meantime. Yes, Mr. Hazarika. BTC, who's for BTC? BTC, who's there? BTC, Ms. Bora, R.B. Bora. Madam, come. You take instructions. BTC. You instruct that in the meantime you can file affidavit, okay? The other respondents, state respondents, BTC respondents. Okay, next. IA for what? Mr. Sheikh, IA for?
I for amendment, my lord, but I am handicapped, my lord.
Lord,
Junior has not.
They have filed an IA for amending the writ petition prayer. The prayer of the writ petition are already been, my lordship, served, lordship. Because
Well,
they have given the areas led to the petitioner.
Let me
and
submit, my lord. Let me submit.
The IA
Actually,
petitioner have filed.
Oh,
the
just
others
a minute.
it is very difficult, my lord, when some opposite party advocate, without hearing the petitioner, jump up and started to say something. That's very bad. My humble
So my other
submission.
senior is handicapped, there is no brief. That's
No, he has got the brief.
No.
He has got the brief. Brief has
Not
come
to
to
worry.
him.
Yeah, my lord, my humble submission before your lordship. Actually, what happened? Some portion of the order is carried out. But what happened, my lord? I was appointed in 1983. They want to decide my pension in a new pension scheme. So, my lord, unfortunately, my lord, I could not hesitate that matter initially. That is why, my lord, I want some amendment. That is the question.
You'd like to file objection in the IA?
Lordship, I did not understand even what he has written in the IA. My
That's
lord, may kindly have a look the IA. It is a form of writ petition, my lord.
Then, my lord, I have written some wrong English, which is not
After
understandable
hearing the
to my
parties,
side.
please to have allowed their force and amendment sequence. Paragraph 3, let us see paragraph 3.
Is it possible to amend each and every paragraph of the writ petition, my lord, in the form of an IA? The petitioner may withdraw this case and file a fresh. I have no objection.
Amendment, my lord, without looking into the record, my lord, this type of submission is made. I was allowed by this honorable court for filing amendment. Record is not looked into.
My lord, may kindly have a look the IA filed by the petitioner.
Mr. Sheikh, don't you think that these are matters which will change the nature of the writ petition?
No, my lord.
This is a
Because, my lord, my humble submission before your lordship, I was appointed in 1983. So my case is to be considered.
No,
under
that is what we are trying
Yes,
to
my lord.
extract from you.
My lord.
By this IA, you are trying to bring in the aspect of new pension scheme and old pension scheme.
My lord.
That was not the subject matter in the writ petition which was originally presented before this
No,
court.
my lord. That was not the subject matter, my lord. Your lordship would be pleased to see the original prayer of the writ.
Of the writ petition.
Yes, my lord.
Okay.
That is WPC number
3088.
3088 of 20.
52 page.
Prayer is at page 16.
Yes, page 16, my lord.
Yes.
Under the above facts and circumstances, it is therefore prayed that your lordship would be pleased to admit this petition. Call for the record. Issue a rule calling upon the respondents to show cause as to why a writ in the nature of mandamus shall not be issued to direct the respondent to pay the arrear salary of the petitioner with effect from 1/7/2013 to 31/1/2015, and to show cause as to whether petitioner shall not be paid his pension. The pension prayer is there, my lord. Pension and other service benefits.
But
That is here.
new pension scheme, old pension scheme, that's a different matter.
My lord, that is why, my lord. That is
Why did
why.
you file a separate writ petition?
That your lordship will decide.
You file a
But
separate writ,
my-
it will be easier for you, easier for
Madam,
us.
Let me place my
Yes.
whether new writ petition or this amendment will be allowed. Paid his pension. The word pension and other service benefits. That is there, my lord. Only thing is this, my lord, I am to amend this writ petition, whether my case will be pension matter will be decided in old pension scheme or new pension scheme.
That is an independent,
I
cause,
want to
that is
go-
an independent cause of action.
My lord.
In fact, there are many matters, as you know,
My lord.
whether it be governed by old pension scheme, new pension scheme.
My lord,
Your
that
claim
is-
to pension is a different matter.
My lord, actually, my lord, I humbly submit before your lordship. When this matter was before your lordship, earlier occasion, then I said that I want to withdraw and I will file a fresh writ petition. Then your lordship said to me, that why new writ petition? You amend the
Which order?
order is there.
No, Lordship, this
Just-
honorable court has directed him to withdraw this
Madam,
petition.
madam,
No, no, I was the counsel for the respondent. I was present, my lord.
madam, take your seat. We'll have your chance.
Amendment petition. My lord, your lordship would be pleased to see order dated 4/3/2024.
Yes.
Petitioner is allowed to file appropriate petition challenging regularizing order dated so and so.
No, 4/3/2024 is not such an order.
My lord,
4/3/2004 order passed by Justice Honorable Justice Saikia
my lord.
is recorded that so and so present. Sri Sheikh, the learned counsel for petition, prays for filing necessary application seeking amendment of the writ petition. Prayer is allowed.
Yes.
Prayer is allowed. You have filed it. Now you have to see whether such a filing is not barred, but whether we can
That is
interpret
why
that.
what I submitted before your lordship, that word amendment possibly there.
Yes. No, so
Petitioner is allowed to file appropriate petition.
No. According to writ petition is deferred for 3 weeks, enabling him to file necessary application for amendment if so advised.
If so advised.
That is the order.
That is the order, my lord. So my interpretation before your lordship is this. I was allowed to file amendment petition.
No, allowing
Amendment petition.
allowing you to file amendment petition, does it?
We are on this point.
No, does
By
it,
that-
does it amount to allowing the amendment
That
at
is
all?
all right, my lord. Your lordship rightly pointed out. I have no dispute. But thing is this, my lord, what my learned friend is submitting, that there was no question of filing amendment.
No, you may be correct.
Yes,
That
my
issue
lord.
had arisen.
That is why, my lord, my humble submission before
That
your
issue
lordship.
has arisen.
My humble submission before your lordship was that I have filed this amendment petition, whether your lordship will allow or not,
That's a different
in
matter.
pursuance of the order.
You're correct.
But my learned friend saying that,
No, there was a discussion.
yes, my lord. So, my lord, my humble submission before your lordship, if your lordship do not allow my amendment petition, that it will enhance the nature and character of the petition and fresh cause of action. So I may be allowed to withdraw and that observation.
I
with
think
the
that will be the
petition may
best.
be
And
closed.
there, the contesting respondents will also have a fair opportunity to contest.
That is
Okay,
the-
heard, heard Sri M.A. Sheikh, learned counsel for the applicant. Also heard Miss M.D. Bora, learned standing counsel,
WMD department
welfare of minorities
and
and development department, Mr.
Number 2, 3, 4,
and
5,
Mr.
7.
Borpujari for,
Code of Finance Department.
and Sri R, Sri R. Borpujari, standing counsel finance department, and Sri C.S. for respondent, for the state
1
respondent.
and 9.
For the state respondent, full stop, para.
Correct.
Sri Sheikh, before going into the IA, has referred to the order dated 4/3/2024 passed in the writ petition, by which the petitioner was allowed to file application for amendment if so advised. Okay. He has submitted that in the prayer of the writ petition, apart from the aspect of pension, the other service benefits have also been categorically stated, full stop. He accordingly submits that the amendment which pertains to the aspect of which pertains to as to whether the petitioner would be governed by the new pension scheme or old pension scheme should be allowed Full stop. Para. The IA has been, the government, the statements made in the IA have been perused along with the documents annexed. Full stop. This court is perused. Full stop. Ms. Bora, the learned standing counsel, has submitted that by the IA, by the amendment, by the amendment sought to be done, comma, the entire nature and character of the writ petition would be changed. Full stop. Para. The aforesaid submission has also been supported by Sri Borpujari and Sri Hazarika, the learned counsel. Full stop. Para. The statements made in the IA and the materials placed before this court have been examined. Full stop. The aspect as to whether the petitioner would be governed by the new pension scheme or the old pension scheme is an independent aspect which is to be decided by this court independently. Full stop. In the fitness of things and for the convenience of the parties, comma, the petitioner, the applicant petitioner, this court is of the opinion that instead of making the process cumbersome by amending the earlier, the connected writ petition, comma, the petitioner is required to file a fresh writ petition, taking the aforesaid aspect as a specific matter of relief prayed for. Full stop. Para. I is accordingly dismissed by giving liberty to the petitioner, to the applicant, to file a fresh writ petition, which may be done expeditiously. Full stop. Such writ petitions which may be filed would be heard analogously with the existing writ petition.
Obliged.
Obliged. My lord, may kindly have a look the last order of our report.
IA for?
As for impeachment, lordship, applicant is the wife of the
My lord, may kindly have the last order.
opposite party number 1.
Order dated 5/6/2024.
Okay, let us Yes, what is your explanation?
Lordship, I filed my affidavit today only, lordship.
Where in the IA?
In the IA, lordship. Today only.
Lordship,
My
report
only
was sought
explanation
from the
is, lordship,
registry, my
the
lord.
petition, applicant's husband engaged one advocate, lordship, Mehtabuddin Ahmed, in the month of April 2019.
Okay, let the affidavit come. We'll examine.
The report is also called from my lord registry.
কোনটো আছে আচ্ছা দেখি আমি একেলগে খুলিম আৰু 2টা বজাত শুনিলো at 2 o'clock.
My lord. Obliged.
লৈ আহিবাচোন
Lordship, today only I filed an affidavit. Lord.
regarding
Regarding, lordship, as per order, last order, lordship, I have given explanation how this petition. Actually, lordship, petitioner husband has engaged one counsel, lordship, in the month of April. But lordship, therefore, there is no, there is some communication gap, lordship, probably filed after. Lord.
and what is the review?
Lordship, my lord may kindly have a look the report that was called for by the Honorable Court,
Yes.
reported by registry. Review we have filed. State has filed a review.
যদি কাটা গ'ল চাগে এইকেইটা কাটা গ'ল হেৰিকেইটা কেতিয়াও নাকাটিবা এনেকে চব হেৰিবিলাক আছিল চব লিখাবিলাক আছিল ইয়াতে কেতিয়াও কাটিব নালাগে চাই ল'ব লাগিব Yes.
My lord. We have filed a review against the order of the Honorable High Court dated 10/12/2021. In our review petition, the petitioners, the earlier
The
petitioner was
petition has been disposed of already.
disposed of, and we have directed to pay the pension. That's why we have filed a review, but because we could not pay him the pension because he is the ACC employee, their service condition is different. So we have filed a review petition. In our review petition, the IA has been filed. In their IA, they have annexed the death certificate of the writ petitioner. That's why we came to know that review petitioner died on 8/6/2019, and the writ petition was filed on 18/7/2019, after 1 month of death of the petitioner. That I have brought on record. Notice this Honorable Court, and Honorable Court has passed this order. My lord, in similar matter in not existing person, lordship has already decided such a matter.
What is this?
Lordship has decided.
What is the order now? Where is the order which is you want to be reviewed? Page?
Lordship, in our review petition, my lord. It's in Lordship, page 114, my lord.
114.
The relevant paragraph is my lord, 119, paragraph 10.
After the writ petition, you had filed affidavit in opposition.
Yes, 2 affidavits we have filed.
No, thereafter was any rejoinder filed.
No, nothing. No rejoinder was filed. The writ was instituted in the year 2019, and this Honorable Court has disposed of this matter in the year 2021. Nothing has been filed. And we have filed 2 affidavits. The ASTC has also filed affidavit in this matter, as he was the employee of the ASTC.
No, order cannot be, writ petition cannot be instituted by a dead person. What is the IA for?
I have for impeachment of the lordship applicant wife.
In which case?
In review.
How? Where is the provision? What role will you have in a review? It was instituted in the name of a dead person. It was continued for 2 years. You did not take any steps at that time. Forget yourself impleaded. If, assuming there was some mistake at the initial stage, but mistake cannot be continued for 2 years.
Lordship, the wife is not aware that the case has been filed after expiry or.
Now, how was the case? Okay, it was not, she was not aware that the case was filed after expiry, but she knows that the case was going on. She did not take any steps to get herself substituted. What was the order here?
Relevant.
Review has come for the first time.
No, ma'am. 2-3 times the review came. And last occasion, after filing the IA for substitution, this Honorable Court has passed this order for inquiry matter. This is the order dated, my lord, may kindly have a look again. Order dated 5/6/2024.
In the review?
No, my IA, my lord. May I read, ma'am? 5/6/2024.
Just a minute, let us say the review. But even in your review, you did not take up the issue that he was a dead person.
After filing the IA, we came to know
No, you are the employer.
he already retired, Lordship.
Understood, but somebody will make a claim.
That's why we filed a review in the name of the person by name is the respondent. We're not aware because he's not a pensionary service, no, his service.
Department is aware because Lordship, as I've gone to Lordship, wife has already applied for pension along with this order, along with the order of the.
This is different issue, but the writ petition has been filed after death of the person. Whether department is aware is not. The petitioner has abused the process of judicial process, my lord.
This review in any case has to be allowed, not on the grounds, even not on the grounds taken by the review applicant, on the ground that there was no person. It cannot have been passed. And what about the inquiry report? What action is to be taken?
My humble submission, my lord, lordship may dismiss the writ petition and allow my review.
Writ petition has already been allowed. We cannot pass orders in the writ petition. We pass orders in the review.
My lord may pass order in the review petition.
And what about the action against the persons, advocates, clerk, notary?
That up to my lord, I have nothing to say.
Cannot live like this.
Yes, sir.
The instant review application has been preferred by the
There was some
state government through the Department of Transport with regard to a judgment and order dated 10/12/2021 passed in WPC 5063 of 2019. Full stop. The stand of the review applicant represented by Ms. M.D. Bora, the standing counsel, is primarily on the ground that the services rendered by the petitioner was under
the ASCC, lordship, his service condition is under the OM of 31st March 1970.
was under the writ petition was under the ASTC and was not covered by the laws, by the rules and regulation
Okay,
concerning the department.
my lord.
Full stop. There is a separate or office memorandum
Lordship.
for the employees of the ASTC,
Sure.
and this vital aspect could not be pointed out before the court while disposing of the writ petition. Full stop. The matter has, however, taken a completely different turn on filing of an IA, being IA 1410 of 2024, by which one Srimati Parul Pathak has sought impleadment. The said incumbent, who claims to be the petitioner, or claims to be the wife of the writ petitioner, has stated in the IA that the husband of the, that her husband had passed away on 8/6/2019. Full stop. This court, having noticed that the writ petition was instituted on instituted, filed, writ petition was filed after filed on 18/7/2019.
Sir.
And coming to a conclusion that it was instituted in the name of a dead person, had directed an inquiry to be paused by the registry. Full stop. The registry through the registrar judicial had made an inquiry and has submitted the report dated 21/6/2024 in seal cover, which has been opened. Full stop. The while the the statements of the concerned advocates, notary, and the advocate's clerk have also been recorded. Full stop. The inquiry report in clear terms has recorded that there were gross anomalies while filing the writ petition, as admittedly the filing was done on 18/7/2019 in the name of one Ganesh Chandra Pathak, who had passed away on 8/6/2019. Full stop. Para. Though grounds have been taken for review, this court is of the view that when it is not in dispute that the writ petition was instituted in the name of a person who was already dead, who had already passed away before such institution, the very inception the writ petition was not maintainable from the very inception. And in fact, for inception, full stop, this court is also intrigued by the fact that the petition, which was instituted in the year 2019, was continued and continued till the final judgment and order was passed on
10/12/2021,
10/12/2021. Full stop.
more than 2 years.
It is absolutely shocking as to how the conducting council had continued with the writ petition, which was admittedly instituted in the name of a dead person. Full stop. Even giving the benefit of doubt that No, your lordship, full stop. It is also wholly unbelievable as to how the person could be identified and she has sworn the affidavit in presence of the notary. Full stop. Para. In view of the aforesaid facts and circumstances, comma, this court is of the opinion that the order dated so and so 10/12/2021 is otherwise also cannot be termed as a valid order, as this court was projected with wholly incorrect facts leading to passing of the said order. Full stop. Accordingly, comma, the aforesaid order stands reviewed and the writ petition is dismissed. Full stop. Para. This court also directs the registry to furnish a copy of the inquiry report with other particulars to the respective authorities, including authorities governing the persons who are involved in the filing and conducting of WPC 5063/2019, so that onward action may be taken in accordance with law. Full stop. Such action is required to maintain the sanctity and decorum of this court. Full stop.
I'm so deeply obliged, my lord.
In view of the order, final order passed in the review application, comma, no orders are required to be passed in the IA so and so, which is accordingly dismissed.
I'm so deeply obliged.
AG. Four, 5, and 6. Yes, next.
Petitioner before lordship, my lord, are on contractual, my lord.
What is this
basis.
IA?
Well, I have for my lord non-payment of my salary, dues and current salary, my lord, page 12, my lord.
Which department?
The reason behind is that, my lord,
Which department?
my lord, NHM, my lord.
NHM, yes, madam.
The instruction regarding the salary.
Salary not paid since how many days?
My lord, from the month of March, because my lord, we approached for the Honorable Court, stay order was granted, and
Madam, you take instructions, you cannot withhold salary.
my lord, the problem is that, my lord, one of the, there are 4 writ petitioner. One petitioner is very severe because his parents.
No, we'll have it, we'll fix a date within 2 weeks. Have the instructions.
Monday, my lord, possible.
Not Monday. Not Monday. We'll have it on Friday next.
My lord, only one observation. So far, current salaries are concerned, that may be continued, my lord. That will not harm, my lord.
Words, Sri S. Chamaria Learned Counsel for the applicants, writ petitioners, who by means of this application has prayed for a direction for release of the outstanding salaries from the month of March 2024 to June 2024, and also for payment of current salaries, full stop. It is submitted that only because of the fact that the writ petitions has been filed, comma, the salaries have been stopped, full stop. Miss Bora, A. Bora, Learned Standing Council, NHM, prays for some time to obtain the instructions, full stop. Para. Since the matter pertains to payment of salaries, comma, list this matter on we'll have it on 1st of Friday. Friday get over. 2nd of August.
One observation, otherwise.
Pendency shall not be a bar for payment of the current salaries. Give an extra copy to
Today.
Mr. Hazarika. What brings you here? Nineteen. Which item, Mr. Gogo?
Length of the writ petition, one of the petitioner has been promoted. From grade 4 to
No,
grade
sir,
3.
Mr. Kakoti was there in the first half. Where is he now? The time was sought for on your behalf in the first half. We'll have it on Friday or Monday next.
Monday or Friday, it can be otherwise
Uh,
closed.
No, we'll close it in his presence, not in his. He was there in the first half, not be fair. Sri B. Gogoi, London Standing Council, Health Department, Finance Department submits that during dependency of this case, one of the petitioners have,
Been promoted to junior assistant.
yes,
Yes, my lord. This matter, respondent side has filed a affidavit in opposition, sometime may be given to file rejoinder.
David, petitioner number 2 could not be promoted because there is no vacancy.
that, किसकी आलिखल है इसमें? Promoted, and though the other petitioners were considered, they could not be promoted. Full stop, para. What is your name?
P. Thakuria.
Sri Thakuria, are you on record?
Yes, my lord.
Sri P. Thakuria, learned counsel for the petitioner, however, praised for and is granted 3 weeks' time
Yes, sir.
to file rejoinder affidavit. List after 3 weeks.
Masuk.
Please, the topic. I was supposed to take steps upon the newly implemented response of our district topic.
Number 7.
On newly implemented response, I'll take steps topic.
Okay. Ms. A. Tarukdar, learned counsel for the petitioner, submits that due to inadvertence, steps have not been taken upon the newly implemented respondent number 7. Full stop. See praise for and is granted 2 days time to take steps by registered post to AD as indicated in the order dated 14/6/2024. Okay.
Maybe lot. Lord, these files file for withdrawing the WBC number 30. My lord, only count that the petitioner assistant are filed this case, my lord, and they are now ready to individual capacity. They file their written.
I for Union of India, CGC. CGC. There are many CGCs right now. Where are they now?
Where also there, my lord, finance, health.
Finance, health. State government is there.
Yes, my lord. State government.
State government, Mr. Nath.
State government is also there. Health, government, finance.
Okay. Wait for a while.
Why stop?
Meet with the lordship.
Yes.
In this case, the lordship, I was serving as the branch manager of Poltonuzar branch of UCO Bank, your lordship, and I was dismissed from service on 10/1/2018.
After a DP?
After the deployment proceeding. Your lordship may kindly peruse the page 54, the article of charge.
Just a minute.
May I read you?
You were appointed as what?
I was serving as the branch head of Cotton Bazar branch, UCO Bank. Your Lordship.
Where is the charge memo?
54, Your Lordship.
5-4.
Five.
Mr. Sharma, have your seat.
May I read, Your Lordship?
54.
50.
Yes, please.
Sri Kondapur Kumar Kolita, senior manager, presently under suspension while functioning as branch head at Cotton Bazar, 1925.
When are you suspended?
Lordship,
Okay, doesn't matter.
From 8/10/2012 to 6/11 to 16/11/2013, had allegedly committed several acts of omission and commission, details of which are mentioned in the statement of allegation for which Kondapur Kumar Kolita is charged as under. Sri Kondapur Kumar Kolita, employee number 35097, has failed to take all possible steps to ensure and protect the interests of the bank and discharge his duties with utmost devotion and diligence, which is violative of
Now,
regulation.
where are the incident? These are the charges. Statement of allegation.
Statement of allegation starts at page 56.
Yes.
May I read it?
Hmm.
Sri Kondapur Kumar Kalita, employee number 35097, senior manager, Yahabari branch, presently suspension with effect from 14/10/2016, while posted as branch head at BO Bolton Bazar 1925 from 8/10/2012 to 16/11/2013, had committed following acts of omission and commission.
These are not the allegations. Where are the allegations?
The allegation starts at page, then you'll have to.
60?
It is a
No.
type of. This 56 is a type.
No. These are the allegations, Your Lordship. From Sri Kondapur, the 1, 2, they have 6 allegations, Your Lordship. The first allegation is from 1. May I read, Your Lordship? Sri Kondapur Kumar Kolita sanction and disburse cash credit limits to different borrowers in gross violation of bank's rules, regulations, and procedure. Sri Kolita indulged in gross irregularities as mentioned below in sanctioning of the borrower limits and grossly misutilized his position as senior manager and branch head of Cotton Bazar in absolute violation of the rules, guidelines, and procedures of different loan schemes of the bank, and jeopardized the interests of the bank as well as made huge financial loss to the bank. This is one, Your Lordship. I'm skipping the names and all. Then Your Lordship may kindly come to page 59. May I read, Your Lordship? Page 59.
59.
59, Your Lordship.
Yes, please.
Sri K.K. Kolita is branch head of Cotton Bazar branch most irregularly and fraudulently allowed preparation of fixed deposits of the debit to the debit of third-party account to be retained as collateral security to facilitate sanction of cash credit limits. The debit in the third-party accounts were made good by credit transfer from the borrower account on sanction of the limit, which resulted in wrongful diversion of bank's fund. Such wrongful diversion of fund took place in the following accounts. So I'm not reading the accounts, Your Lordship. Then 3. Sri Kondapur Kumar K.K. Kolita is branch head of Cotton Bazar branch most irregularly and fraudulently manipulated entries in the system pertaining to loan sanctioned by him. While entering the fixed deposit as collateral security in SRM menu, Sri Kolita kept the due date earlier than the maturity date, and accordingly, lien was lifted prematurely. The prematurity proceeds was used to be transferred to bill realized account, and on the same or later dated bill realized accounts were debited an overdue amount on each credit limit service, and fixed deposits were created to serve as collateral security. The Kolita indulged in such acts in different accounts as follows to suppress the irregularities in the loan portfolio. Then I'm skipping that, Your Lordship. Then 4. Sri Kondapur Kumar Kolita, employee number 35097, the then senior manager of Cotton Bazar 1925 branch, presently under suspension, sanctioned UCO Bank loan to fictitious persons to cause wrongful gain to himself and wrongful loss to the bank. There are as many as 85 UCO cash loans in different names during his tenure as branch head for a total amount of rupees 165.54 lakhs, and thus Sri Kolita failed to take all possible steps to ensure the integrity and devotion of his duties. Then, Your Lordship, I'm skipping that. Then 6, page 61, Your Lordship. I'm just reading the allegations, Your Lordship. 61.
$61.
61, Your Lordship.
Yes.
6. Mr. K.K. Kolita is branch head of UCO Bank, Cotton Bazar branch, 1925 branch, connived with one Sri Vikrant Kumar Roy, proprietor of Messrs. Ma Traders, account number 1925051, 0001444 to indulge in irregular and fraudulent activities in loan portfolio for wrongful gain to himself and wrongful loss to the bank by accepting introduction of the Bharat Vikrant Kumar Roy in different opening accounts of most of the borrowers, including 23 fictitious UCO Bank cash borrowers of NF Railway Sapormuk. The cash credit account of Sri Vikrant Kumar Roy was used for preparation of third-party FDRs for making collateral security of other borrowers. On sanctioning of fresh credit limit to new borrowers, the amount of FDRs prepared were reversed back to the CC account of Vikrant Roy, and thus diversion of loan proceeds from various loan accounts sanctioned by Sri Kolita for his wrongful gain and wrongful loss to the bank. 7 year old KK Kolita's branch had indulged in irregular and fraudulent activities in loan portfolio for wrongful gain to himself and wrongful loss to the bank. There was suspicious cash deposit in account number so and so of Mrs. Vinita Kolita, wife of KK Kolita, as under. These are the allegations, Your Lordship. Then Your Lordship may kindly peruse the inquiry report, which is a page 98.
Yes.
May I read the third paragraph straight away, Your Lordship? In the inquiry report, page 98. In the course of inquiry proceeding, the PO submitted 155 sets of documents, all of which being relevant to the allegations as subject charge sheeted were accepted by the EO as management exhibits. A copy of each of these sets of MEs was given to the CEO for information. The PO produced one management witness named Sri Tapan Chakraborty, employee number 40546, manager of circle officer, Guwahati UCO Bank, and presented the management case for examination by MW as also by submission of the basis of ME. Now, Your Lordship, in this case, there were 155 exhibits, Your Lordship, 155 documents, and all these documents were of different things, Your Lordship, different persons, but only one management witness, Your Lordship. There ought to have been an endeavor made by the inquiry officer to at least examine the witnesses who have executed the documents, Your Lordship. An endeavor was not made. One person going through while exhibiting 155 sets of documents, Your Lordship. In my respectful submission, Your Lordship, this was an error committed by the inquiry officer. They ought to have examined more witnesses, Your Lordship.
So, David, this is not a
Yes, Your Lordship.
civil proceeding.
I understand, but at least
That should not be a ground.
Yes, yes.
Cite your substantial grounds. You may
Yes,
have
yes.
good grounds.
Yes, Your Lord.
Don't start with a weak ground. Start with the strongest ground.
Just pointing it out, Your Lordship. Then page 99, Your Lordship.
Yes.
This is the gist of allegations of, and the articles of charges against the CEO, Your Lordship. I'm not reading everything, Your Lordship. Then Your Lordship may kindly come to page 105. EO's assessments of evidence and PO and the CEO DR.
105.
105.
Yes.
The account Messrs. May I read? The account Messrs. BMB Enterprise was sanctioned under UCO Trader scheme by the CEO on 29/2013 for rupees 23 lakhs. As per the bank guidelines, the UCO Trader loan at the time should have been sanctioned as per the bank circular by material exhibit 1.1 and material exhibit 1.2, but following irregularities were observed. UCO Trader loan is to be sanctioned for trading purpose only, but as per trade license issued by Guwahati Municipal Corporation, by material exhibit number 1 to BMB Enterprise, Professor Hamiz Ahmed, the business is related to manufacture of cloth and skin bags. Further, as per the IT returns of Hafiz Ahmed for AY 2011, 12, 2012, 13, and 2013, 14, 5 material exhibit 1.7, page number 5, material exhibit 1.8, page number 5, material exhibit 19, page number 5, it is clearly mentioned as gross receipt from manufacturer of clothes and resting bags and its materials. Thus, the very purpose for which the loan was sanctioned deviates from the bank's guidelines. May I read it? Thus, the 1.1.b, as per material exhibit 1, page number 4, for limit above rupees 20 lakhs but below rupees 50 lakhs, the latest audited financial statement has to be obtained. But as per material exhibit 1, 7, 1, 8, and 9, the financial statements submitted are not audited, hence the guidelines are not followed. Your Lordship may kindly, if Your Lordship may permit me, may I read my defense, Your Lordship? Then it will be clear. At page
139.
Yes, Your Lordship.
139 is the second show calls. Yes. 140.
Yes, sir. May I read, Your Lordship? With reference to your letter number so and so, I have the honor to state before you the following views, comments on the assessment and finding of the inquiry officer of POC Paramanando Pal, AGM retired. Allegation number 1.1, 1.12, 1.3 of Messrs BMB Enterprise. BMB Enterprise is not only manufacturers product but sells the products to its customers, and simultaneously it indicates the trading activities also. The loan is secured by collateral security to landed property of the guarantor, which is duly mortgaged, and the EMTT has been duly created. The value of the property is more than enough to protect the interest of the bank dues. As per modified UCO trader scheme, it is satisfied the norms of sanction. The loan amount is rupees 20 lakhs and the realizable value of the collateral security is 32 lakhs, which is more than 125% of the loan amount. Hence, this allegation does not sustain against me. LICI payments made by the borrower to checks were cleared to a clearing at clearing house, which I did not have any knowledge about it. Hence, this charge does not sustain against me. Allegation number 2, Your Lordship, the value of the collateral security of the landed property is rupees 32.25 lakhs against the loan amount of rupees 24.50 lakhs, which is more than 125% of the loan amount sanctioned. This satisfies the terms of the modified UCO trader scheme. The mortgage property is in the name of guarantor and the EMTT is duly created. The loan amount is easily realizable from the value of the mortgage property, so the bank's interest is protected. Hence, this allegation against me does not sustain. Whether with 1.13, whether such transactions have been made in the account is purely business oriented, hence the allegation is totally incorrect and by hypothetical in nature. 141 page, Your Lordship, 1.4. Although there were some procedural lapses at the time of sanction of the loan, the account is fully adjusted normally by the borrower without losing a single paisa to the bank. The closure statement is produced before the EO, hence the allegation does not sustain against me. All the loan proposals were recommended by another officer. After proper recommendation, loans were sanctioned. Disbursement of loans also done by 2 officers, so it cannot be said that the loans were sanctioned single-handedly. Full KYC documents obtained from the borrower, genuine salary certificates were issued by the authorized persons of various departments. EO in his statement had mentioned the word maybe, which is not at all acceptable regarding the grave allegation. Hence, this allegation against me is not true. The status of Messrs Chaudhary Enterprise is a performing asset with effect from 39/2016, whereas the allegation in the charge sheet is dated 2/5/2017. Hence, the allegation is not at all substantiated against me. There is no fictitious or fraudulent account found. Full KYC documents were obtained for all the borrower accounts. I was not aware of all the transactions in the accounts since I was busy with other managerial work. Mr. Vikrant Kumar Roy is our old and bona fide customer since long, and he is not blacklisted by the bank. And there is no question of non-acceptance of his introduction. Transaction in his account cannot be doubtful, hence allegations cannot be substantiated against me. Allegation number 7, I have already told that my wife, Mrs. Vinita Kolita, took financial help from her brother, friends, and relatives and deposited to her SB account for meeting up the cost of her daughter's marriage ceremony later on. There is no any evidence regarding wrongful gain to myself, since the money deposited to her SB account by my wife is totally non-related to me. I myself honestly advised her to deposit the borrowed money to her bank for the interest of the bank. If there was any evil intention, I would have advised her to deposit the money to any other bank. The allegation is imaginary and totally hypothetical in nature, hence the allegation does not substantiate against me. The conclusion, Your Lordship, at 142. Since my joining our bank on 8/7/1983, I have been working sincerely with utmost devotion for the development of my beloved institution. During continuous 33 years of service, I have not done anything which is detrimental or against.
On the factual aspects, merits of the charges.
Yes.
show us the procedural irregularities. We are a secondary authority.
Yes, your lordship. The procedural
The
irregularity.
primary authority is the disciplinary authority, already taken a decision. You show the procedural irregularities or some aberrations in the law.
That is what I was on, your lordship, because they had not considered my case at all, your lordship. They ought to have at least considered my defense.
No,
They had not- the disciplinary-
that is a submission on merits.
Yes.
You show from the procedure that what this procedure is grossly violative or I have not been fairly treated. And this is the settled law, how you have to proceed, you have not done.
They had not considered my case, and then, your lordship, 143, they had passed the order without considering my case, your lordship. That is my case. They have not at all considered my case. Without
That is-
considering my
that-
case, they had passed an order.
that
And
is
the
not-
punishment, your lordship,
Yes.
the punishment, my respectful submission, your lordship.
143 is the penalty order,
143 is the penalty order, your lordship.
penalty of dismissal.
Yes, your lordship.
Yes.
4 of the charges were proved against me. One was, 2 of them were not dropped, your lordship. One was partly proved.
Yes.
And with respect to the quantum of punishment, your lordship, they have not been able to prove anything, your lordship. Still, on the preponderance of probability also, your lordship, they ought not to have come to this conclusion that I was guilty of the charges, your lordship. Yet they had,
What is the standard of proof required in a disciplinary proceeding?
your lordship, in my respectful submission, at least the other witnesses ought to have been examined to establish the fact that I was involved.
Which
in those
other
transactions.
witnesses?
Other witnesses, your lordship, the documents that they have gone through. These documents, your lordship, may kindly peruse a judgment of
That
the honorable-
will not be relevant at all.
And the quantum of punishment may kindly be considered, your lordship. I have worked for such a long period of time.
How
I'm
long?
dismissed from service, your lordship.
How long?
For 33 years, your lordship. I was at the verge of my retirement when they had done this to me, your lordship. The quantum of punishment, your lordship. I'm also on the quantum of punishment, your lordship. I understand, your lordship, it's a case where it is only preponderance of probability that is required to prove the charges against me. But in my respectful submission, your lordship, even in the quantum of preponderance of probability also, they have failed to establish the charges against me, your lordship.
Mr. Deori, you have not done your homework. You have grounds. You have not even noticed the grounds. You have not done your homework.
Sorry, your lordship, I pardon.
You are harping on merits. You will not gain anything by harping on the merits of the allegation.
Yes, sir.
Unless the findings are grossly perverse to the evidence on record.
Yes, sir.
There is something else.
Your lordship, they have not issued a second so-called notice to me.
Why not? It has been given. You have replied to the second
Yes,
so-called
second so-called.
on 1/21/10/2017. Page 139 is in the second
Yes, sir.
so-called notice. So Deori, you need to read laws before you come to argue.
Your lordship,
What is this essence of a second so-called notice?
no,
Please
second-
explain. What is
so-
the second so-called notice?
Second so-called notice, your lordship, there is a second so-called notice, I have replied to it. The second so-called notice is required only because I need to be given a proper opportunity, your lordship.
For
So that
what?
I can reply to all the allegations they have
Proper
brought against me.
opportunity against what?
For the punishment and the charges.
Not
that
for
were
the
brought-
punishment,
For the charges that were brought.
not for the charges. For the findings arrived at
That is
by
right.
the inquiry officer which are against you.
Exactly.
Have you read the second so-called notice?
The second show cause
You have
notice,
not read the second show cause notice.
at page 139, Your Lordship.
Please read.
You are, may I read, Your Lordship?
Here.
We are enclosing here with the inquiry report dated 25/9/2017 submitted by Sri P. Paul, AGM retired inquiry officer, for your comments on finding of the inquiry report. On careful examination of the report, it is observed that 7 allegations against number 31, 32, and 33 have not been presented by the PO, but other allegations have been held substantiated according to charge number 1 to 4 be held proved. Since I concur with the above findings of inquiry officer, as charge number 1 to 4 are proved, you are advised to submit your comments point-wise on the inquiry report within 5 days from the date of receipt of this letter, failing which it will be constituted that you have nothing to offer, and I, being a disciplinary officer, will proceed further in the matter without further reference to it.
What is the meaning of this?
The allegations, Your Lordship, according to this report, they have not been able to establish all the charges.
Not all the charges. Charges, allegation 31, 32, 33 have not been
proved.
proved. Others have been substantiated. Then what does it do, this disciplinary authority? First line of the second paragraph.
Parawise comments on.
First line of the second paragraph.
Since I concur with the finding of the, he has concurred with the finding of the inquiry.
So where is the effective second so-called notice?
Yeah, yes, Your Lordship, I understand, Your Lordship. I beg to,
So where is the
apologize.
case law on this?
Yes, Your Lordship. I want
Which
the case
one?
law. That's-
You don't reverse the roles. You
I
are,
understand.
you are the
I'm
council.
extremely sorry, Your Lordship.
Court is not the council.
Yeah. Your Lordship, 2010 to SCC 497.
What is it?
I've given a case, the case laws are there, Your
2010?
Lordship. 2010 to SCC 497, Your Lordship.
Name?
Name is G. Valli Kumari versus Andhra Education Society and others. Paragraph, Your Lordship, 19 and 20.
Yes, what has been stated?
May I read, Your Lordship?
Have you given case?
Yeah, I've given a copy, Your Lordship. But it's there in the file, Your Lordship. এখন তাকে কখন দিতে হবে? We take it as given this judgment along with citations, Your Lordship.
Yes.
Paragraph 19, Your Lordship. May I read? In his order, the chairman of the managing committee.
Just a minute. The first one.
No,
2010.
2010 to SCC is the third one, Your Lordship.
Third one.
497.
Yes, paragraph?
19. May I read you?
19.
19.
Yes, please. Yes.
May I read you? In his order, the chairman of the managing committee did refer to the allegations leveled against the appellant and representations submitted by her in the light of findings recorded by the inquiry officer, but without even adverting to the contents of her representation and giving a semblance of indication or application of mine. That is.
This year, the response was not taken into consideration.
Yes,
on that aspect.
He is also not.
We are on the different aspect. We are on the effectiveness of a second so-called
Yes,
notice.
Yes, Lord. Therefore, there was no escape from the conclusion. The order of punishment passed by the chairman without complying with the mandatory 11th statutory rule and the principal ministerial justice. Yes, I have another judgment.
Which one? Mr. Dev, come prepared.
Yes, sir.
You have citing 12 judgments. The judgments which you should cite, that is not there.
Yes, sir. I extremely sorry, Your Lordship.
You should focus on the grounds which will may be available to you.
Yes, sir.
Beating around the bush will not help you.
Yes.
So many judgments you have cited. The main judgment you have not cited, which perhaps will help you. But we are not going to say which judgment. You need to find out yourself.
Yes, sir.
Mr. Sharma will have it some other day.
Your Lordship, may I pray, Your Lordship, on Thursday, next Tuesday or Thursday?
Next Tuesday we'll have.
Deeply.
Come prepared on this point, specific point.
Yes, Your Lordship.
That if he concurs while sending the second show cause notice, where is your scope of convincing him not to accept the inquiry report?
Do Your Lordship. I am.
Your Lordship, can it be taken on 1, 2, or 3 of the next month, Your Lordship, if allowed? Because that it is a month and we have to file all the reports.
Okay,
so
first
that
of
will be very short.
August. 1st of August, Thursday.
Yes, sir.
First, can you, is it okay?
Yes, yes,
for-
yes.
1st of August.
Highly obliged.
Deeply.
এখন কি আছিল আগৰ কিছু নেকি আচ্ছা
Item 16.
16.
Yes, sir. You withdraw, my lord, the association and liberty.
Yes. You want to withdraw the IA?
No, my lord. WBC, my lord.
You want to withdraw it?
Yes. And
Why do you want to withdraw?
and liberty to file a case, my lord.
No, why do you want to withdraw?
My lord, this WBC was filed as the association. But some of the member of the association filed the case, my lord. So they suggested we come to individually, my lord.
Okay. Heard Sri H. Ali, learned counsel for the applicant. Also heard Sri H. Ali, learned standing counsel for
Health and Finance.
Health and Family Welfare Department. Finance?
Finance also, but
Both for the Health and Family Welfare Department as well as the Finance Department. Fourth para. The learned counsel for the applicant petitioner by means of this I has sought to withdraw the writ petition. First of it is submitted that while the writ petition was instituted in the name of the association, comma, the affected individual members would like to file separate writ petitions. What's the para? In view of the aforesaid submission, comma, writ petition is dismissed on withdrawal with liberty as paid for.
For individual, the members are liberty to individual.
No, with liberty as paid for. We have recorded. I had to pass করলো আয়াত passes. হ্যাঁ দুইটা করিস তাহলে একেবারে 54 I accordingly stands allowed. This. Yes. Item number.
Hello, my senior Mr. and Mrs. Anantarpur. After what amount of time?
Content 54 pension measure.
Who is your senior?
Mr. Anand Chaudhary.
Mr. Chaudhary has some difficulty. We'll have some other.
Maybe
Okay. On a prayer made on behalf of Sri N.N.B. Chaudhary, learned counsel for the petitioner. Matter is adjourned to be listed when? Wednesday next. Next Wednesday.
It is hearing matter, but it is hearing on Thursday.
Is it hearing?
Yes, it kept this heading of hearing today.
On Thursday next. Not day after tomorrow? Or not tomorrow, next Thursday.
Next Thursday.
Okay.
Obliging.
First August.
Lordship, remember, my lord, that because of slow progress of that departmental proceeding, my lord, lordship directed the respondent to submit the instruction in regard to the my lord time frame for the purpose of completion of departmental proceeding. Now, lordship, there are two issues which is corrected here. Number one, my lord, the so-called notice was issued 9/2023. Almost 15-16 months has elapsed.
Yes, Mr. Nath.
Yeah, but I have got this letter. They have informed. The second page kindly see below. Date of appointment of IO and presiding officer, presenting officer, investigating officer, named the presenting officer, and they have indicated that the inquiry officer has already completed the hearing of the witnesses and the delinquent officer. Inquiry report is expected tentatively by the month of August 24.
No witness has been examined, my field date. Lordship, kindly just look for a moment. The last
Completed the hearings and the witnesses.
Pardon?
Witnesses have been recorded.
No, my lord, absolutely not, my lord. It's a very surprise to say, lordship, just look for a moment. On 19 March 2020, last communication I have received from the concerned officer, inquiry officer, to appear before him. Accordingly, I appeared. Thereafter, it was informed that the proceeding would be initiated. Nothing has been done.
This was of March.
Yes, my lord. Thereafter, nothing, my lord. I never been told, my lord.
Very good. Very good for you. If they proceed without any witnesses.
My lord, that's
You take the
last occasion it was told.
Mr. Nath, what is this?
But my instruction, written instruction, I go by that. And go by that. I would pray, my lord, Lakshmi, give us 2 weeks time. They will 2 months time. They will complete because by August they are getting the report, and after that, my lord, the report has to be given to her and reply, and then they will find it.
No, that is okay. But what he is making a categorical statement that he is not even aware that witness. When did you take instructions?
My lord.
When did you last take the instructions?
This one, my lord. Yes, yesterday, my lord. My lord, I am in touch with that, my lord, petitioner. My lord, I am following up the thing. My lord, thing is that my petitioner, this petitioner even made a prayer before them that in order to cross-examination, a lawyer may be appointed, my lord. That prayer was even not entertained.
No,
Let me complete. Therefore, on that last point, my lord, this matter is now lying, my lord, pending, my lord. Thereafter, my petitioner even approached before the concerned authority to initiate the proceeding. Nothing, there is no any response. Sometimes he absent, sometimes, my lord, there any communication.
Okay, we'll record your submission. Okay. Pursuant to the order dated 8/7/2024, passed by this court, Sri D. Nath, the learned senior government advocate Assam, has obtained written instructions. Full stop. By placing the said written instructions dated 23/7/2024 before this court, Sri Nath has submitted that after appointment of the inquiry officer and presenting officer on 14/2/2024, the inquiry has already been completed and the hearings has already completed, the inquiry officer has already completed the hearings of the witnesses and the delinquent officer. Full stop. It has further been stated that the inquiry report is expected in the month of August 2024. Full stop. Para. Sri Chamaria, the learned counsel for the petitioner, has however submitted that as per instructions received by him, no proceeding of the inquiry was held even on a single day. Full stop. He therefore disputes that the hearing could have been said to be over. Full stop. Para. Be that as it may, since the learned state council is equipped with written instructions, this court for the time being would go by the same. Full stop. As requested on behalf of the department, the disciplinary proceeding is directed to be completed by passing final orders within a period of expected within a period of 2 months from today. Full stop. It is also made clear that as per the statement made that the inquiry report is expected tentatively by the month of August 2024, once the same is furnished to the delinquent petitioner, the response to the same would be furnished by her expeditiously so that the matter can be completed and brought to a logical conclusion.
My lordship, my second fault is that, my lord, about the suspension part. It's a very serious thing. In the garb of this departmental posting, I am the sufferer, my lord. Lordship, can you see that the charge, whatever that is being pressed, important to my lord, development cooperation, which I have left in 2021, my lord. Now I am suppose holding last posting to secretary, my lord. Now I am far away from there. There is no scope that I would interfere anywhere in any document or whatever, my lord.
Sri Chamaria, learned counsel, prays for an appropriate order with regard to the prolonged suspension. Full stop. Though the said prayer has been considered. Full stop. This court records that in the time given by this order for completion of the proceeding, if the proceeding is not completed within the time given in this order, this court would consider passing appropriate orders for revocation of the order of suspension and reinstatement of the petitioner in any non-sensitive post.
Lord.
The written instructions is made part of the records.
Lord.
This you take it back.
Otherwise, I have copy, man. No problem.
Okay. But he is also correct. Unnecessary suspension is neither helping you nor him, you are paying the 75% essay.
No, ultimately, my lord,
Lord,
it-
may I
it's a-
refer one,
that-
3.34?
That's true. It's a large scale kind of scam.
No, no,
Ultimately,
Mr.
question of public trust is also there.
No.
To be put in a particular.
No, Mr. Nath, that aspect we cannot ignore. That's
Look.
a relevant aspect. But you are paying a person without utilizing his service.
Yes.
That is also not good for you.
True.
You complete the inquiry as soon as possible. If you think that the allegations are substantiated.
I have
If it is not substantiated,
Yes,
then
Mr. Of justice, my lord, if
I
suppose
have-
this
I have
side go, or this side go, but there must be a conclusion of that.
Yes,
inquiry.
yes.
Lordship, only one thing is wait, 3.13.2. which
of
is
the
a part
manual, manual, of the manual.
Now, Lordship, nothing has been done, my lord, in terms of that manual method. That is the manual there.
The matter will come.
Let us fix a date.
Right.
List on, we said 2 months.
2 months.
Yes.
That will
Today
be-
is 24th.
Let it be on 30th of September.
Not 30th, not immediately before the October vacation. We'll have it on 25th of September,
Ma'am,
Wednesday.
neck to neck, matter.
Okay.
Hip level.
Eight is your lordship. Lordship, this petition was filed by the petitioner for granting of the first financial application.
Yes, where is Mr. Dutta? You're there? Okay.
He was denied of his 10 months application, lord.
Now you're appointed where? When?
I received the appointment letter on 22/12/2005. I
22
joined in the service on 27/12/2005. And
No, appointment letter is 22/12.
12/2005.
Appointment as?
I joined on the service on 27
As
staff nurse.
staff nurse.
Yes.
Then what happened?
Therefore, I joined on the service on 27/12/2005.
Okay, joined.
Yes, lordship.
Then
Thereafter, I was working. Then there was a suspension period of 10 months, lordship. That was
suspended.
Suspended. But
Yes.
according to Government of India Office Memorandum, the suspension can be only extended to 180 days, lordship. But I was suspended for 10 months, which is not valid. And during the suspension period, the disciplinary proceeding was not conducted. It was conducted after the expiry of the 6 months.
Okay. Then
And because of that, my first upgradation period has been delayed, lordship, which has to be received in the year 2017. It was given to me on 25/1/2018.
what upgradation?
First financial upgradation, lordship. That is
After
after
10
completion.
years.
After 10 years.
You are given when?
I was given in the year 2018, lordship, 25/1/2018.
Yes. Then
Thereafter, I resumed my service and I was given my first financial upgradation. And when I received my upgradation, I had objection to it because I had to receive it earlier. So I made representations to which there is-
the subject matter is the subject matter of this writ petition
yes, sir,
is the date of effect of the first upgradation.
first financial upgrade.
But why did you come to the court in 2021? If you think that you should have been given in 2017 and you were actually given in 2018, you came to the court in 2021. Why so late?
No, the office order was given to me, was passed on 19/1/2021, Lord.
Regarding
regarding this financial upgradation. That is on page 20.
19-1-21.
Yes. To which I raised objection, Lord.
No, by this 19-1-21, your upgradation was given from 25-1-18.
Yes.
Let us see page
20.
20. 20.
It is serial number 10, Lord.
Mr. Datta, please have your seat. We'll come to you.
My lord,
Have your seat. We'll come to you.
my
Let
lord,
her complete.
my lord, one that disciplinary proceeding has been initiated, suspending the petitioner for his act.
We'll hear you. Have your seat. We'll let her complete. Then we'll come to you. Yes. Please have your seat now. 19. This is, you are at 10. Madam?
Sorry. Yes. Serial number 10.
Manik Chandra Devamari.
Yes, sir.
Okay.
Thereafter, I made the representation to the department on 29-1-2021. That is at page 22.
29-1-21. Yes.
21.
Yes.
And that is annexure number 4.
Yes. Representation. Then what has been done?
To which the respondent did not comply with my prayer.
Now, when are you reinstated? You said that you were suspended from service after joining. When was the date? When were you reinstated?
I was reinstated
For 10 months.
for 10 months.
Then what happened to the disciplinary proceeding?
The disciplinary proceedings was initiated after the expiry of the 6th.
What happened thereafter?
And thereafter,
Some
I was
penalty?
given a warning.
Okay.
Yeah, I was given a warning to
No other penalty.
no other penalty. The penalty was that my 10 months increment, I will not be able to receive that. That was there. And I was then reinstated in service in the month of April in 2032.
2013.
2030. That is expiry, that is completion of 10.
When were you suspended?
I was suspended on 12/6/2012.
And reinstated?
Reinstated date is.
No, you said 13 just now. Just now you said 13 something.
Yes.
10-1-13 or something.
It was in the month of May. That exact date is, I have to find it.
May.
May.
May 13.
May 30.
That's all.
Yes, that's.
Mr. Datta, otherwise she completes, she is eligible by length of service 10 years. Whether even if you exclude the period of 10 months, she says that she entered into the service in the year 2005.
Yes.
And the financial upgradation, which she claims is from 2017. He had given from 2018.
10 month deferred because of the suspension. My lord, the departmental proceeding was initiated because of the offense that he has tried to molest a patient. It was admitted by him, but he submitted an apology later. And considering his family.
No, Mr. Datta, if you have exonerated him, maybe on a sympathetic consideration, that will not mean a discontinuation in service.
Punishment was given.
What penalty?
At page of my lord,
Withholding of 3 increments.
three increment.
But
Page,
well, how did you deal with the suspension period? Was it treated to be on duty or not?
my lord, kindly peruse the
where is the penalty order?
office memorandum.
Penalty order?
Office memorandum,
Madam, where is the penalty order?
office mem.
Let us see the penalty order.
The penalty order is not annexed here, Lordship.
That is crucial, madam. How your period of suspension has been dealt with. At times, it is held to be in duty. At times, it is held to be not on duty.
Regarding that case where I had to face the disciplinary proceeding, there is another case filed by the petitioner, Lordship. That is also in progress, Lordship, which is pending in the hearing stage.
No, madam, let us assume that that case goes against you.
Okay.
Let us assume, in worst case, that it is dismissed. But will it mean that there was discontinuation in service? There was no discontinuation.
No, Lord.
And until and unless he is dismissed from service, whether you withhold 3 increments or not, she continues in service. And how do you give the financial upgradation? Only on mere completion of 10 years, or do you consider any other aspects?
The basis of the office memorandum.
Page?
Page, my lord, is, my lord, punishment order, reinstatement order at page 41 of the FPT. Internal page 18.
Yes.
Dated 22nd April 2030. That where third paragraph. Whereas doing money doing my staff nurse Smith has submitted the
Page? That is not because
22nd April 2030.
That is page 45, running page 45, internal page 19, annexure B to the affidavit. There is no indication that it was held to be not on duty.
Yes. No indication, but the office memorandum dated 19 May 2009.
Page?
In clause, in my page 32, regular page 19 of PT. 9 of it. Second paragraph.
Is it 19th May?
19.
19th May is page 36.
page 36, then
My lord, para 2.
Just a minute. Paragraph?
2.
Yes, please read.
The government has considered the recommendation of the Sixth Central Pay Commission for introduction of a MSTPS and has accepted the same with further modification to grant free financial application under the MSTPS at interval of 10 years, 20 years, and 30 years of continuous regular service. Another is that, my lord, office memorandum at 2nd January 2014.
No, Mr. Datta, what this court is asking is to get the MECP's benefits, is length of service the only criteria, or are there any other criteria?
It is break of service, my lord, because 10 months, that is why 10 months differ.
Mr. Datta, you're not even understanding, or we are asking that whether the only criterion is the length of service,
Length of service.
or are there any other criteria?
Any other criteria, my lord, that because of we have not given the deferred benefit because of, we may be wrong, my lord, that deferred the benefit because of the
Mr.
suspension.
Datta, perhaps you are not correct. It is not only on the length of service.
Because,
MSAP is not per se admissible on completion of 10 years, 20 years, or 30 years. You need to fulfill the other criteria also. There are other criteria. Your ACRs are seen, service records are seen.
My lord, as per the
Have you applied your mind to the aspect of MSCPs? Has any order been passed?
Yes, there was a CAT judgment of New Delhi.
No. Has any order been passed on your representation?
They have denied to my representation,
Where?
Lordship.
Page.
That is in their affidavit in objection. That is Annexure E.
Annexure?
Annexure E,
Page.
32.
Internal page 32. I think 58 it would be. Yes, 5/3/2021.
Yes, Lordship.
And the
That
period
was
suspension
their
for the measurement of-
reply from the department, Lordship, to my representation.
See, here you have taken into consideration the aspect of penalty also. How are MSPs granted? How are MSPs granted? What is the guiding guidelines?
10 years, 20 years, and 30 years. As
No,
per
that is
the-
one of, that is the eligibility criteria. You come into the zone of consideration. But merely by completing 10 years or 20 years or 30 years, it is not, or you do not automatically get the MSCPs. What are the guidelines?
the continuous period. Okay. Guidelines is that
Let us see the guidelines for MSCPs. Let us see the guidelines.
guideline is, my lord, the guideline is there.
Page.
Page, my lord, in my page 32, regular page 9. Furnished by the office, furnished by the department, my lord. So, page maybe no. Scheme is 19 May 2009.
Yes, guidelines are there at page 13.
Yes, my lord.
Pa-
Screening committee shall constitute in each department as para 4. Okay. And screening committee shall be constituted in each department to consider the case for grant of financial arbitration under the MSCP scheme. The screening committee shall consist of a chairperson and 2 members. The members of the committee shall comprise office holding posts which are at least one level or above the grade in which the MSP is to be considered and not below the rank of undersecretary equivalent in the government. The chairperson should generally be a grade above the members of the committee. And next page, the recommendation of the screening committee shall be placed before the secretary in case where the committee is constituted in the ministry, department, or before the head of the organization or competent authority in other cases for approval. In order to prevent under strain on the administrative machinery of screening committees shall be followed as time schedule and meet twice in a final year. Preferably in the first week of January or first week of July of a year, or advanced proceeding of the cases maturing in that year. Accordingly, cases maturing during the first half April to September of a particular financial year shall be taken up for consideration by the screening committee meeting in the first week of January. Similarly, the screening committee meeting in the first week of January of any financial year shall process the cases that would be maturing during the second of the same time. However, to make the MSCP scheme operate, the Data Controlling Authority shall constitute the first screening committee within a month from the date of this instruction to consider the case maturing of 30th June 2009 for grant of benefit. In so far as person serving in the Indian state, this is not explicit. NDA interpretation clear.
You come to internal page 7 of the memo. Point number 15 and 18. Running page is 42. In this
18,
notice,
my lord.
15, if a financial upgradation. 18 you are reading?
In the matter of discriminatory penalty proceeding, grant of benefit under the MSCP shall be subject to rules governing normal promotion. Such cases shall be therefore be regulated under the provision of CCS Rule 95 and instruction issued there.
And come to 15. Top, the first one in this page.
On grant of financial
No. The for 15.
If financial application under the MSCP is deferred and not allowed after 10 years in a great way due to the reason of the employee being unfit or due to departmental proceeding, etc., this would have consequential effect on the subsequent financial application, which would also get deferred to the extent of delay in grant of first financial application.
So there are other conditions also. Merely completion of 10 years, 20 years or 30 years will not be enough. That brings you to the zone of consideration. But there are other conditions also, other criteria also, like whether there was any disciplinary proceeding, whether there was any penalty order. Madam, difficult. We thought you had a case.
Lordship, in our case, the disciplinary proceeding was initiated in 2013, that is 16 to 2013. That is after the expiry of 6 months. And there is also judgment where it has been passed that if the disciplinary proceeding is not conducted within the limited time, the MSCP scheme cannot be denied. The judgment is.
Let's see. What is the citation?
Citation is Anil Kumar Sharma versus JNCTD. The judgment
Madam,
is passed.
what judgment are you producing before us?
This is the CAT judgment.
CAT judgment can you produce before a high court?
There are no Supreme Court judgments. It was
Produce a high court at least. Do you produce a subordinate court judgment before a high court? Maybe the CAT has referred to some other judgments. Let's just see.
yes, there is.
No, in the judgment which you are trying to produce
Yes.
for us.
There is another judgment also. That is Union of India versus KV Jankiram.
KV Jankiram, what has been stated?
That judgment
It's a
is
still
also.
cover proceeding. Doesn't nothing to do with MSCPs.
The principle was followed there.
What is the principle?
And if necessary, I will go for the High Court judgments regarding the MSPs.
Now, if on that line you have a High Court or a Supreme Court judgment, that will help you. Otherwise, that will not have any value. How does Janaki Raman helps you?
Uh,
How does Janaki Raman helps you?
Page number 4, paragraph 3, Lordship. The normal rule of no work, no pay is not applicable to cases where the employee, although he is willing to work, is kept away from work by the authorities for no fault of his. In this case, the petitioner has prayed before the respondent authorities that he is not alleged of any offense.
Which paragraph? Janaki Raman?
Page number 4, paragraph number 3, Lord.
3.
3. In this case, he was falsely accused, Lord.
But here, see the preceding paragraph, paragraph number 2. This is in the context where an employee is completely exonerated. Here, in your disciplinary proceeding, there is an order of penalty of withholding of increment in cumulative effect. It's a major penalty.
May I submit another official matter? At page 19, regular page 19 of the affidavit, office memorandum 2nd January 2004. With regard to suspension.
Page
19
of
the affidavit. Number maybe it provided.
office no.
Provided
This pay. What is the date of the?
2nd January 2014. Office memorandum issued by the Ministry of Personnel Affairs.
2nd January 2014. Yes.
Page 50.
Page that is 20. Yes.
At page 18, my lord. Clause 18.
Huh?
Clause 18. And
Clause 18.
18. Page 9 of the memorandum. On conclusion of
Yes, on conclusion.
P, my lord, minor penalty is imposed. Here 18 CB. Next page, my lord. CB. 18 CB. It's the period of suspension. May I go?
Which one?
CB.
C.
18B or CB, my lord.
CB, okay.
CB. The period of suspension shall not be treated.
Yes.
The period of suspension shall not be treated as duty unless the competent authority specifically direct that it shall be so treated.
Have you seen this?
Yes, I have gone through
If
this.
it is a minor penalty, then it is not justified to have you under suspension.
Yes, but
Now, if it is a major penalty, unless there's a direction that you order a period of suspension to be treated on duty, it will be treated, deemed to be treated as not on duty. Difficult case. You have tried your best.
But Lordship, one thing I would like to submit,
Hmm.
the allegation against the petitioner who has made that there was a misdemeanor or misbehavior conducted by him, that allegation was made by mental patient, was a patient in that.
Madam, that is not the subject matter of challenge. You should have challenged it. You have accepted the penalty. If there was another writ petition challenging the penalty, matter would have been different. Here we cannot go into those aspects.
Yes, that case is pending.
Oh, that case is pending.
That case is pending. Still pending. Lordship.
If your penalty is
No, the grievances that Lordship, the
Mr.
initial
Dutta,
discipline
if we pass any adverse order here, she may not get relief in this case, even if the penalty is set aside.
One case of disposal, dismissal.
What is the number
5531,
of?
2021, Lordship. That case was filed earlier.
I think,
One case, my
I
lord.
think both should come together. Because we are not inclined to allow this petition with this materials before us. But if the penalty tomorrow is set aside by the court, then she will have a chance. And if there is a pronouncement of this court that she doesn't qualify, then it will be a conflicting interest.
I have some documents in other cases. My lord, he admitted.
Okay, we will have both the
dismissed it.
cases together.
But
After,
Lordship, if the
we'll
discipline.
have both the matter, okay. After hearing the matter. For some time, this court has been informed that so far as the penalty order of withholding of increment is concerned, the same is the subject matter of challenge in WPC
5531, 2021.
5531/2021 filed by the petitioner. Full stop para. List this case along with the aforesaid writ petition. Is any date fixed in that matter?
No, Lordship, no date fixed.
After 2 weeks.
Obliged, Lordship.
You take this back, Janaki Raman. Next occasion you may give it.
Next, Lordship, Miss M.M. Kotoki, she left the court, Lordship. She was not feeling well, Lordship.
Veterinary department.
Yes, sir.
Yeah. Small issue was required to be ascertained before the court, my lord.
No, we have heard this matter at some length.
Subject matter is, my lord, relating to the promotion, my lord.
Friday? Friday. Day after tomorrow.
Friday or Thursday, my lord.
Next, no, we are having day after tomorrow. Thursday is tomorrow. Tomorrow will not be possible. A prayer for adjournment has been made on behalf of Miss M.M. Kotoki, Learned Standing Council, AHNVT, and Veterinary Department. Para, list on Friday. Yes.
My lord. My lord, yeah, my lord. The suspension was issued to the petitioner, my lord, on 13/7/23.
Yes.
Thereafter, my lord, no review has been done. They have filed an affidavit, my lord, that can be revealed. Lordship, kindly have a look, date, my lord, the date of suspension. I was placed under suspension at page 40.
Date?
Page 40.
Date.
Dated is 13/7/23.
Okay. A post.
Post, my lord, I'm working as a SCF, my lord, in Forest Department,
Assistant Conservator of Forest.
my lord.
Yes.
Then, my lord, I have submitted my representation, my lord, asking for my reinstatement, my lord, on page 41 on 1923, because for some time I was behind the bar, my lord. So immediately I came out from the jail, my lord, and I have intimated to the authority at page 41 to reinstate me, my.
Yes. Your suspension was a deemed suspension.
Yes,
You were in custody.
yes.
Hmm.
Thereafter, my lord, within the statutory period of 90 days, my lord, it was not been reviewed, my. That can be revealed from the affidavit filed by the official respondent, my lord. I like to draw lordship's attention, my lord, at page 74. It was, my lord, reviewed minutes of the meeting to the review suspension case. Page 74. That is the affidavit opposition filed by the Forest Department.
Okay.
Page 74.
Yes.
Minutes of the meeting of the review suspension of the case pertaining to the Environment and Forest Department held on, kindly note down the date,
Yes.
14/2/24 at so and so at a PM in the hall of so and so, my lord. My name, last name, my lord. Suspension as per reviewed. Lordship, kindly have a look, serial number 6. The list of suspension cases placed by Annexure 2 is reviewed, and it has been decided to extend the period of suspension for another 3 months. Another 3 months, my lord. That has been reviewed by the member. Prior to that, my lord, at page 72. That was, my lord, only, my lord, what to do. It was not suspension review, my lord. Lordship, kindly have a look at page 72. Minutes of the meeting of the review of the suspension cases pertaining to the Environment and Forest Department held on 9 at PM in the conference in additional Chief Secretary Environment to the Forest Department, Block D, so and so. There, my lord, they have taken view, my lord, Vinod Kumar Payeng, Nepal Chandra Mandal, that is myself, my lord, to be an others, my lord, Bablu De, STF, be removed from our service. But this is not, my lord, cannot be constituted as a review of my suspension. Review of the suspension is very much there, my lord, in the page 74. They specifically, they state, my lord, the review has been decided to extend period of 6 months or 3 months, sorry. 3 months. But page 72 does not indicate, my lord, the review was done, my lord. Now, my lord, in the applicability of the case, my lord, lordship is aware, my lord, there are several judgments, my lord. And apart from that, my lord, the Vinod Payeng, my lord, it was clearly covered by this, my lord. If your lordship kindly permit me, my lord, I'll just place, my lord. Seven, 5, 3, 23. First, can you have a look, this, my lord? Clearly, will other judgment is also there, my lord. Basically, this is clearly covered case, my lord. In my case, my lord. Had it been reviewed in time, my lord, then otherwise, my lord. But it has not been reviewed in accordance with the provisions of the law.
Yes.
And my lord, lordship will see the page 55, my lord, of also a similar kind of judgment of his honorable court, my lord. There also, my lord, it has been told that the Ajay Kumar Chaudhary, my lord, the retrospective meaning of that, my lord, in the para 20, my lord. Operative part, lordship can be seen at page 60, my lord. Para 16 at page 60, my lord, the funding of the court, my lord, similarly. That also been, my lord.
Yes, yes.
Lordship may remember. Another, my lord, judgment I have also annexed at page 62, my lord. Now, lordship are to examine, my lord. Lordship kindly have a look for a moment at page 64, my lord. Page 64, para 6, my lord. It has been discussed various judgments of our High Court, my lord. Para 6 of another judgment, my lord. Rakibuddin was also there, my lord. Ajay Chaudhary also there. Ajit Sonowal is also there, my
Okay,
lord.
no, that is okay. Now we have to ascertain the factual aspect.
Yes, my lord.
Whether the timely review was not done within
My
the
lord.
period prescribed. That is the only.
Yeah, that is only my limited grievance, my lord.
Yes, Mr. Botakur.
Lordship, as per our affidavit, we have annexed the review meeting. But as the first review is, Lordship, it is very well review, even though my senior from the other side is saying that it's not a review, but the heading, Lordship, says minutes of the meeting to review our trap suspension cases. And
Now, what is the date of this?
the date is 11/12/26.
11?
12/26.
No, page 72.
Lordship.
What is the date?
11/12.
No, not 11/12. This is the meeting of 9/11. Why are you missing out this? Meeting is of 9/11. You have
The
9/11.
minutes of the Lord. It was signed in.
Signed is 9/11.
9/11.
So from date of suspension, when was the date suspension?
Suspension was 13/7/20.
So even if we hold this to be as a review, is it within 90 days?
Well, beyond.
But Lordship, the intimation, it was sent in, it is in the petition itself, 1st of September.
What?
Intimation about him being released on bail, Lordship. And
Not
while the officer is in custody, Lordship, it would not be practically possible for the officer to be reinstated. And hence, Lordship, in the Rafet Ali judgment, this honorable court had started counting the 90 days from the time the intimation of the officer being released on bail is
Now, what is
received.
the expression used by the statute in regulations 6(4) or 6(2)?
6(2).
6(2). What is it?
Some disciplinary aptitude.
Where are the rules, Mr. Botakur?
The first. 6(2).
A government servant who is detained in custody, whether on a criminal charge or otherwise, for a period exceeding 48 hours, shall be deemed to have been suspended with effect from the date of such detention. So there is no ambiguity in the statute.
Yes,
Statute says from the date of the detention, if you are behind the bars from 48, you will not even go counting from after 48 hours. From the date of detention, the counting will start. That you have gone on deemed suspension. Rakibuddin, we have held, a division bench has held that even Rakibuddin, even a case of deemed suspension would be should be treated at par with a suspension contemplating a disciplinary proceeding as held by Ajay Chaudhary. Rigors of Ajay Chaudhary will be applicable even in a criminal case of 6-4, 6-2, 6-2. So that being the position, even if we construe this to be a review, 9/11 is beyond 90 days.
But if we count it from when the intimation was sent,
No, it is not from intimation.
because in Rafid Ali judgment, I have a copy.
What was the arrest was on for what count?
But the petitioner was caught red-handed.
So arrest was not on not for an offense which is not connected with the office. Had it been an offense that he was engaged in some assault or some rape or some murder which you are not aware. Here it is an offense in the office, trap case. You are aware whether it's intimated or not. It's your duty that 90 days whether he's given bail or not.
No.
But,
you have to review.
But even otherwise, since Ajay Chaudhary, the Supreme Court judgment forms the basis of all this, in Ajay Chaudhary, if Lordship sees, it is subpart.
Yes.
In para 22, Lordship, if you
Yes,
see at page 54,
Yes.
says since memo of charge has already been submitted, and therefore these principles would not apply to the petitioner, and therefore
Memo of charge was issued when?
it was issued in 14th of March. Sorry.
14th of March. It is beyond 90 days. The first line, where is Ajay Chaudhary? Page?
I have annexed, my lord. Lordship
54.
kindly have a look at page.
54.
Yeah. It starts from page 42.
Yes, come to page 54, paragraph 21. The first line itself, first sentence itself, Mr. Borthak, please read. We therefore direct that the currency of a suspension order should not extend beyond 3 months if within this period the memorandum of charge sheet is not served on the delinquent. That means if you serve, then matter is different. You can still put him under suspension. But if you have not served, it will go. And if you want to extend it, you have to make a review. That is the law. Okay.
That I admit, Lordship, that this was passed after delay.
No, and what is troubling us that it appears that the offense against the petitioner is serious.
It
In
is
your
serious.
first meeting at page 72, you have discussed the seriousness of the matter, and you have even thought about that you should dismiss him summary without a DP. To that extent, you have thought about. You should have extended this suspension order. Okay. Third, three. No, don't write it. The judgment could even. Please have your seat. If there is anything, we'll ask you. An order of suspension dated 13/7/2023 of the petitioner from service is the subject matter of challenge. Full stop. Amongst the grounds taken in this petition, subject matter of challenge in this petition filed under Article 226 of the Constitution of India. Full stop. Amongst the grounds taken, comma, the lack of periodic review within the stipulated period of 90 days is one of the prominent grounds. Full stop. Para. The facts projected in the petition is that while the petitioner was serving as Assistant Conservator of Forest under the Nagaon Forest Division, comma, he was arrested on 12/7/2023 in connection with ACB PS case number 51 of 2023. Full stop. The petitioner was accordingly an order of suspension dated 13/7/2023 was accordingly issued in terms of
which appears to be in terms of Rule 6(2) of the Assam Services within bracket Discipline and Appeal bracket close rules 1964. Full stop. It is the case of the petitioner that more than 90 days had elapsed and no action was taken for his reinstatement, and accordingly, the petitioner had filed representation. Full stop. The representation. Accordingly, since the petitioner continues to be under suspension, comma, the present writ petition has been filed. Full stop. Para. I have heard Sri J.I. Borbhuya, learned counsel for the petitioner. Full stop. I have also heard Sri I. Bothakur, learned counsel for the Forest Department, who submits that affidavit in opposition has also been filed on 9/4/2024. Full stop. Para. Sri Borbhuya, the learned counsel for the petitioner, has submitted that it is on the ground of the arrest of the petitioner that he was placed under suspension by invoking the provisions of Rule 6(2) of the aforesaid rules of 1964. Full stop. By relying upon the case of the Honorable Supreme Court of Ajay Chaudhary versus so-and-so reported in so-and-so, along with the decision of a division bench of this court in the case of Rakibuddin, State of Assam versus Rakibuddin, reported in so-and-so, the learned counsel has submitted that the division bench has clarified that the requirement and rigors which has been laid down by the Honorable Supreme Court in the case of Ajay Chaudhary Supra would also be applicable to a case of deemed suspension. Full stop. The learned counsel has also drawn the attention of this court to 2 minutes of meeting. Full stop. By the first minute of meeting held on 9/11/2023, comma, though the discussion is on the aspect of review of the suspension, comma, it is submitted that no exercise of review as such was done. Full stop. He submits that the review was done for extending the submission, extending the suspension only on 14/2/2024, by which time the period of 90 days was already over. Full stop. He has submitted that though the memorandum of charge has in the meantime been submitted, comma, that is beyond the prescribed period of 90 days and will not have any effect on the law laid down regarding the requirement of timely review. Full stop. Para. Per contra, comma, Sri Bothakur, the learned counsel for the department, has submitted that the first meeting held on 9/11/2023 was on the specific issue of review of the suspension of the petitioner along with some other officers. Full stop. He submits that the intimation of the arrest of the petitioner was made to the department only on
1/9/2020.
1/9/2023, when the representation was made, and therefore from the said date, comma, the even from their said date, it is beyond. Even from 1/9, it is not within 3 months, 90 days. 1/10, 1/11, 1/12. Oh, 9/11 you're, oh, and construing the meeting held on 9/11 to be 9/11/2023 to be a meeting, to be on the aspect of review of the suspension, comma, the same is within time, full stop. It is submitted that the charges against the petitioner are grave and reinstatement may not be in the interest of justice. Full stop, para. The rival submissions have been duly considered. Full stop. The aspect of timely review of an order of suspension is no longer res integra. Full stop. The Honorable Supreme Court, in the aforesaid case of Ajay Chaudhary Supra, has in categorical terms laid down the requirement of review of suspension within 90 days if the charge memo has not been issued in the meantime. Full stop. Para, for any reference, the relevant paragraph, the relevant observation is extracted here in below, paragraph 22. Full stop. Para. As indicated above, comma, a division bench of this court has held that cases of deemed suspension under Rule 6(2) of the rules of 1964 would also have to be treated with the same rigors as laid down in the case of Ajay Chaudhary. Full stop. The relevant paragraph, the relevant observations are extracted herein below. Full stop. Para. Para. In the instant case, comma, the order of suspension is of 13/7/2023. Full stop. The same was admittedly passed on the ground that the seven. No, where is the arrest?
I was arrested, my lord.
12/7/2023. 12/7/2020.
12/7. It is. This is not under 6(2). Though the aforesaid order does not reveal that it has been passed on the ground of the petitioner being arrested on the previous day, comma, it is the arrest and detention of the petitioner which had triggered the authorities to pass the aforesaid order of suspension. Full stop. Even assuming, full stop. Nonetheless, comma, since the order of suspension states that it has been passed contemplate a pending trial of a departmental proceeding, comma, let us proceed with the assumption that the suspension is not a deemed suspension, full stop. Be that as it may, comma, the requirement of timely review of an order of suspension is a mandatory requirement, full stop. In the instant case, comma, the department has relied upon an order, a minute submitting held on 9/11/2023, full stop. A perusal of the aforesaid meeting, though would give an impression that the same was on the aspect of reviewing trap/suspension cases, comma, the minutes do not reflect that there was any application of mind or any orders passed towards extending the order of suspension, full stop. The order of review appears to be done in a minutes of meeting held on 14/2/2024, whereby a conscious decision was taken to extend the suspension, which includes the suspension of the petitioner, full stop. In any event, comma, both the meetings were held beyond the prescribed period of suspension, prescribed period of 90 days from the date of suspension, full stop. Therefore, it becomes immaterial as to when the petitioner had informed about his arrest, full stop. In any case, comma, the arrest and detention was not because of any offense unconnected with the office, but with an offense directly connected with the office, and therefore it cannot be contended that the authorities were unaware of such arrest, full stop. The aforesaid discussion would also not have much relevance as the order of suspension, which is passed on 13/7/2023, is pending trial of departmental proceeding and not for the arrest and detention of the petitioner. Yes, anything?
The requirement is release, intimation of release on bail, not intimation of arrest.
On intimation of release, huh? But that is not relevant. It's not deemed suspension.
Only reason
No,
why.
but it's not relevant. Had it been a deemed suspension, then also. Release, intimation of release, huh? More identity. Para, as already observed above of the law laid down by the Honorable Supreme Court and also by the division bench of this court, comma, the review done for extending the suspension is admittedly, which is beyond the period of 90 days, cannot save the respondents from the legal obligation cast upon them, full stop. The order of suspension dated 13/7/2023 is accordingly interfered with, full stop. Para, at this stage, comma, Sri Bhattakur Dilanis, counsel for the department, has reiterated the seriousness of the offense, full stop. Para, considering the above, comma, while the suspension has been interfered with with a direction for reinstatement, comma, the authorities are at liberty to post the petitioner in any non-sensitive post, full stop. The revocation of the suspension order shall not, comma, in any way affect the ongoing disciplinary proceeding.
Statement henceforth.
Okay.